Yes, sir.
Matter relating to regularization, and the London CAT also declined to interfere. So that's why Maharashtra admitted similar matter. That is the.
You have admitted similar matter?
Yes, matter. The 2-3 matters my lords are admitted.
So 1 and 2 are similar?
Yes. 5 matters, 5. One matter is left out.
Notice is issued, not admitted. No. Notice. Let the counsel for the petitioner draws our attention to our order dated 21/5/2026, whereby notice has been directed in a cognate matter, that is WTC number 37839 of 2025, and therefore issue notice in this matter as well. First off, usual 17 pages, 3 working days, right? All along with the WTC number 37839. Okay. Number 2 also same.
Yes.
Fine. So on our accepts notice for 1 and 2. One. Emergent notice to the rest.
Second case, I am
Call along with the
Second place, you are the petitioner.
OP number. So on our request accepts notice for OP number 1, emergent notice to the rest. Call along with 1 and 2 together. Yes.
Item 3, WBC 10995/2026.
Emergency. Stay.
Is there for recovery of vehicle.
What is that? No. Come on. Application test. That's what we say.
So vehicle has been registered. Vehicle was to be
Impossible. Impossible.
Item 4, WBC 16841/2026.
Yes, brother. You want to withdraw?
Yes, sir.
Wait.
For filing better place.
Counsel for the petitioner has filed a memo in the open court taking leave to withdraw the petition with liberty to approach the court again with the necessary modifications for rectifications in the pleadings. Liberty granted, and accordingly petition is disposed. Yes.
Item 5, WBC 173/2026.
This matter relates to untimely transfer of the petitioner, violating the rational transfer policy.
How long your client has been in the place?
He's a scientist in D category.
Scientist in D category.
Yes. Central Groundwater Board. That is in the
Central Inland Water Board. Groundwater.
That's it. He is placed now at Bhubaneswar and he has been transferred to Bhopal.
In Bhubaneswar, how long he has been in Bhubaneswar?
2 years and 1 month.
What is the retention period on the normative process?
Retention period is normal lordship 2 years.
2 years are over.
2 years and 1 month only.
How 2 years means 2 years.
Lordship. And another, that is an office memorandum that Lordship may kindly come to page 49. That is also violated.
What office memorandum says? Who has issued the office memorandum? What is the legal status of this memorandum?
Lordship, the office memorandum dated 30th September 2009.
Who has issued this?
Lordship, it is the Government of India, Ministry of Personnel, Public Grievance and Pensions.
Under which rules?
That I am placing, Lordship.
This is the letter.
Posting of husband and wife at the same station.
As far as possible.
Lordship, the predicament in this the petitioner case is that petitioner came from the Raipur to the Bhubaneswar in the year 2022, and he again transferred to Bhopal in the year 2000.
You said he has been transferred to. You came to this place when? Bhubaneswar, you came to when?
Lordship,
You said 2 years, 1 month. It cannot be. Going by your latest statement.
Lordship, kindly come to page 36.
26.
Lordship. At serial number 2,
Why you are saying all that? We are asking you, when did you come here? Why will you make us to exercise more than what is required for the case?
14/1/2022.
14/1/2022. Therefore, your first statement that he has been here since 2 years, 1 month is wrong, if not false.
It was transferred to, he was transferred to it. And he again transferred to from Bhubaneswar to Bhopal on 13th March 2024. That's it, page 39.
In 3/24.
13/3/2024.
Did you go there?
No, he challenged this transfer order before the learned cat of Attack bench.
It's set aside.
No, it was pending at the interim stage. He was.
We continued till today.
Yes.
How long you want to be in Bhubaneswar? Do you own property here beside Lord Jagannath temple?
I have some problem, Lordship.
Huh?
I have some problem, Lordship.
What problem?
Problem is now my wife, who is working in a bank, he has been transferred to West Bengal.
Huh?
That's it.
So you will go to West Bengal.
I am ready to go to West Bengal, Calcutta.
Did you give that representation?
I have given that proposal.
Sure.
That's it. That I have not annexed. I will annex in the next week. So.
No.
Because of the
Can't waste the time that way. Because of that pendency of the matters. We are against pendants. You make representation.
Let's solve this matter.
Nothing will not pass over also. We are ready. The challenge in this petition is to the order of the Central Administrative Tribunal dated so and so, whereby petitioners OA number so and so have been rejected. First time, in the said OA, petitioner has called in question his transfer order, whereby he sought to be shifted from Bhopal, from Bhubaneswar to Bhopal.
May I have some other submission?
What is in transfer matter? You have seen Shilpi Bose. Supreme Court said what you should hear, what you should not hear. Beyond that, we cannot go like that. It's not Ishwananda.
Let's see what happened is my child is studying in class 4
Yes.
at Bhubaneswar. And my mother recently passed away. And my wife is there at Calcutta.
Sorry. You make a representation. We give liberty, let them take a decision on that.
Yes, Lord.
Okay? But you report at Bhopal first. Then your representation will be considered. See what Varadara Supreme Court said?
Lordship, I deep
Next. Next paragraph. Learned counsel for the petitioner submits that the transfer order being contrary to law and the norms laid down by the memoranda, the same ought to have been voided by the tribunal. First time. He also adds that his wife being employed in Calcutta presently on transfer, he will be satisfied if liberty is given to his client to make a representation seeking a spousal placement on normative basis. First time. Next one, having heard learned counsel for the party and having perused the petition papers, we decline indulgence in the matter in as much as we do not find any legal or factual lacking in the order imputed order of the tribunal. First up, the apex court in Varadara, the state of Karnataka, here so and so, has held that in transfer matters ordinarily, the writ court should not grant indulgence subject to all just exceptions into which argued case of the petitioner does not fit. First up, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation to the concerned authorities seeking redressal against the transfer order in question in accordance with law. Of course, such a representation, if made, shall be considered by the concerned authorities only if the present on transfer order is obeyed by the petitioner by reporting for duty at the transferred place, namely Bhopal, and not otherwise. First of all contention from the parties as to the consideration of the representation or kept over. First, the concerned authority, after considering the subject representation, shall inform the result of consideration to the petitioner. Forthwith. No cost. Show evening.
Milan Kumar, Your Lordship.
Yes.
Yes. It has been added, item 7, WPC 177 05 of 2026.
Yeah.
Just that.
I am for the opposite party here. The company has come on appeal against the orders passed by the Learned Tribunal. It relates to compassionate appointment, and the initial case was filed in 2019. And that was ordered in my favor. Only it was mentioned in that order that reconsider the case of the petitioner, even with all the observations, taking into account their objections filed therein. And again, my lord, they rejected the claim of the petitioner on the same ground, and I challenged it again. And this time in second round of litigation, the Honorable Tribunal has dismissed, saying that the issue was already taken up by this court, the Tribunal, in earlier case filed in 2019. And taking into account the same grounds, it has been rejected once again. That's why the way has been allowed. Compassionate appointment, the daughter. In the meantime, the employee has died. The wife and the daughter are still suffering till now, Malad.
You are for the employee, the aspirant.
No,
You are
Malad.
for
I am the
management.
aspirant. No, I am
aspirant.
Malad.
With that disability. But employee is dead now.
Requires consideration. Having heard the counsel for the petitioner, having perused the petition papers, come up a prima facie case is made out in our opinion for admission. First, admit. First off, call for record, issue notice. So and so accepts notice for all notice.
One appeal.
I am on cabinet.
Call for records.
There is delay.
Tribunal also filed an IF.
A for what?
Interim operation of the interim order.
So,
Well, also, I can take no day for tomorrow. Also, today I am serving the copy to my learned senior.
that's all right. But you equal copies. You make out case for consideration of the idea. Well, any contempt is fine.
No, also, they have not.
It is open to the petitioner to move or pressing the interim prayer. If grounds do come out. Okay.
May I pray, Malad? I am already on the cabinet, Malad.
Yeah, not given any order.
Malad?
We are not given any order.
No, Malad, the order is in my favor. May I pray, Malad? The wife and the daughter, they are suffering since 2019. It can be disposed of.
There are many other aspects, no? Matter requires deeper consideration. Yes.
Item 8, WPC 176.
Yes.
Challenging the e-sale notice dated 9/3/2026.
When did you take the loan?
My lord, 9/3/2026.
No, loan.
Loan 2021.
What is that?
Personal loan.
Personal loan.
Now it's 12 lakh. They're demanding the 12 lakh.
Date of loan is
2021.
No, 31st. When did you take that? 31st, 8/21. No, that is a demand notice.
So that 20
the date. Months. We are not asking for hours and minutes and seconds.
2021 date is not.
We don't know. You may say we have taken it in 2020s. That will not serve the purpose. You have to give full facts, material facts to the writ court if you want justice at our hand.
My lord. It is not mentioned below 2020.
Dollar rupees. Variable counsel for the petitioner to take preparation and make argument thereof. Yes.
This is a court matter. Only prayer is made direct to the opposite party number one for early disposal of the
All these six, how many cases? 1, 2, 3, 4, 5. It is pending before CJM.
plus
In all cases, it is CJM.
Section 14. Section 14.
plus it's
You are the lender bank.
yes, plus
The lender bank is knocking at the doors of Great Court, seeking a direction to the authority, appropriate authority constituted under the SARFAESI Act 2002 for entertaining application 5 of section 14. Personal learned counsel, panel counsel appearing for the bank vehemently submits that applications of the kind have to be treated on a war footing, and that having not happened, a direction be issued for treating the same accordingly. First, in support of that, he cites this bench's decision in WPC number 3873 of 2026 between Vartana Finance Private Limited versus Chief Judicial Magistrate Jaipur and others. Disposed of Jaspur and others. You are right. Disposed of on 24 to 2026, wherein there are 3 reads as under. Put the 3 added. Okay. Note next paragraph. Notice to other side is unwarranted in as much as it will have full opportunity before the tribunal, before the concerned authority, if law does provide for that. First, we are not expressing any opinion as to noticeability of the matter. First, next one, in the above circumstances, these petitions are disposed of by directing learned Chief Judicial Magistrate Khordha to hear and dispose of the subject applications within an outer limit of 4 weeks. 4 weeks. First, in that connection, all conditions are kept open. Next paragraph. Non-compliance of disorder or delay in disposal of the pending application shall be viewed very seriously.
Pardon to mention 3-1-29. After 13, 3-1-29.
Previous matter.
3-1,
29.
2020.
Minor.
You obtained the loan on 3-1-2020.
Minor.
How much?
Yes, 8 lakhs 76,000.
8 lakh
76,000.
76,000.
17.
Minor.
What is that, my
76 or 17?
76.
76.
8.76.
Minor.
It's a personal loan.
Minor.
No guarantee was given.
2 guarantor minor. OP number 3 and 4 minor.
3 and 4 are guarantors.
4 and 5 minor.
4 and 5.
Minor.
1, 2, 3 are who?
1, 2, 3 are bank minor.
Now what happened?
No, e-sale notice and issue by Annex 5 minor.
Yeah, if money is not paid back, what
I
they
am
should
ready
do?
to pay minor. I have filed application. I have
How much
filed
money you are paying today?
50% minor.
50% you are paying today.
Minor.
Today only.
Within 1
Within 1 week.
minor.
Now it is auction is scheduled on which day?
24/6/2026.
24/6 is a day after tomorrow.
And 24/4/2006 minor.
Already over.
Already over.
Auction is over.
Minor already.
Then
Yes.
what can we do?
OP number 6 is now the auction purchase the minor.
That's all right. What we can do, if auction has happened, you have to go under section 70.
I have
That's
already
what Bafna says.
Annex 4 minor. I have given a OTS application.
That makes no sense. You take up all contingencies before the tribunal.
I am ready to pay total.
You say that to the tribunal. We are not super DRT. All right. The short grievance sought to be aired in this petition under Article 226 and 227 of the Constitution of India by the borrower is as to the auction having been done in respect of the security property in April 2026. First time. Very many contentions are advanced by learned counsel appearing for the petitioner borrower. First time. However, we need not undertake a deeper examination of all of them or any of all or any of them in as much as the SARFAESI Act 2002 provides for an alternate and equally more efficacious remedy of appeal under the provisions of Section 17. First off, no extraordinary circumstances are pointed out warranting our indulgence, ignoring the availability of alternate remedy. First off, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to avail the statutory remedy in accordance with law elsewhere, and in that connection, all contentions are kept open. Okay, petition is disposed of.
Item page, WBC 181 issue number 126.
May I please, Your Honor? May I please, Your Honor?
Yes, sir.
The petitioner is asserting the inaction of the opposite party number 1 and 2 bank for non-consideration of representative dated 4/7/2025. My Lord,
4725.
my Lord, we have offered a price for ₹20 lakh by borrowing money from my relative and friend, but they have not considered that and they have issued a sale notice and they have created a third-party interest, my Lord.
You challenge before the hearing.
Direction of liberty.
Petition by the borrower has the following prayer column. First one. The grievance sought to be worked out in the petition can be worked out before the DRT in accordance with law. No extraordinary circumstances having been shown for our interference. First one. In view of the above, petition according to this code of reserving liberty. First one. All contentions kept open. Next. Legislature to send copy of this order to allow peace query to register post immediately, speed post immediately. Next.
WBC 118 2026.
11 is, Your Lordship, the petitioner is before Your Lordship challenging the next 8, wherein again non-consideration of his OTS application, wherein they have specifically stated that
14.
Yes, madam. The OTS application is annexed herewith, where they have stated that if I make a representation further for compromise, that will be done. At this stage, I have come before Your Lordship and I'm ready to pay. I'll pay immediately 20% and the rest 30% within 2 months or 3 months, as Your Lordship pleases.
Now the property sought to be taken possession of.
Yes, madam.
Section 14 order is passed now.
Passed.
Against that order, there is a remedy. Remedy. What?
No, earlier,
What is that?
but earlier you are before this court.
No.
No. Notices of it.
And there is one judgment of brother judge also. Section 14 order is made now.
My lords.
When it was made.
Section 14 is dated 18/5/2026.
18/5/26.
At annexure 8.
That is susceptible to challenge under 17.
My lords.
You go there. We'll observe that.
At this point of time, I'll just make Your Lordship aware that since petition number 2, my wife is suffering from cancer. So, in fact, I was a diligent payer, but the funds have been diverted that way because of the health problems. So,
Where are the medical records?
medical reports I have not annexed.
What cancer? What is the stage of the cancer?
I have taken the specific averment.
Not government.
No,
Evidentiary material.
evidentiary matter, if Your Lordship pleases, I'll produce tomorrow because I have not annexed that. But annexure 6, I have stated particularly about the illness and the.
No, may say so many things, but question is, where is the evidentiary material? Prima facie, to show, yes, my spouse is suffering from science. These sufferings come. We don't say court will not be showing mercy. But where is the standard of the petition? very prominent lawyer of the bar. I'm sorry to say that.
I have taken specific environment.
That's all right. You have said that. The environment can be taken that sun does not exist in the solar system. But where is the material to show?
If your lordship permits, I'll produce that tomorrow.
Pardon.
Item 12, Contempt 1509 of 2026.
Palestinian structures.
Counsel for the petitioner submits, and we agree that the matter be disposed of as having become inflectious. First of order department. Next. Great.
Item 13, Contempt 1607 of 2026.
Item 13, 14, 15, and 16, 4 fresh contempt matters, my lord. Your lordship may grant 3 weeks time to come back with appropriate affidavit, my lord.
Will issue notice.
Yes, lordship may issue
Police notice.
Issue notice.
Police notice.
Great. Grateful. Yeah. Great.
Returnable form. Returnable within 2 weeks. Call on. Give another next date. 2 weeks will be 8 July. 2 weeks will be 7 July. 7 on the 8 post on 8.
Grateful.
Yes.
You have to put the note there. Okay. Warning, what would be the possible punishment? Okay.
Grateful.
Item 17, Major Bill 350 of 2025.
15 days delay is there now. You condone that delay. But not to say return to sender with the VPG number science. Other side is not state of Odisha. Notice and response number. Response number should be on. Well, it's a bit. Go to cross state. Which 20?
DOS. 21 is because there is a private wedding. Or 21, 22 or private wedding.
Others are third. Okay.
These are all commissioners, no? These are all commissioners sitting. They are all commissioners.
They are all commissioners.
They are all
Well, he is not available. The same issue police notice to response number 21.
all of them.
All responded.
Up to
No, but 21 urban is this.
up to 20.
No. 21
are
alone
all
is
private parties. They are all
There are third.
so 20. So
My lord,
21 is private.
Commercial Justice Department, and notice is to be issued, my lord.
No,
No,
21 is a private party.
21. 21 is a private party. He has been upset.
He's only
21. Yes, yes.
Something-
Yes, yes. He is not.
What the litigant should-
He is not responding. He is
Yeah,
not.
he's a private.
That's the issue. Police notice to respond number 21. Then he will come. Yes, return emergent police notice, returnable within 2 weeks. Yes.
Item 18, Medical Bill 382 of 2025.
It was posted to his date, my lord. The item, the previous item,
17?
17.
Ah. Mr. Panda, what we should do? In 17.
In 17. 17.
That's the response number 21 to be served.
Yes.
Let the notice.
Police, yes, police notice.
Ah.
But your lordship kept this matter to which date, my lord?
Since it's a police notice, put a date. 9th July.
9th July.
All right.
Yes, my lord.
Item 18, Medical Bill 382 of 2025.
I am appealing for the respondents matter on
For
40.
respondent.
Ma'am.
Where is your friend? They have 145 days.
45 delay. I have to file the objection to that one.
Yeah. When you serve it, it's a 2025 matter.
Ma'am.
You'll not give time.
The rate appeal generally rate appeal, my lord is considering, but once a limitation is there, Where formal objections are filing. Lordship knows today. Otherwise,
You want to file objection to this?
objection to the
2 weeks for filing objections to IA number 458 of 2025 seeking condonation of delay. Okay.
19, need of it, 421 of 125.
Color.
The appeal by state
Yes, ma'am.
involving a delay of 128 days, my lord, your lordship, may kindly.
Anything significant in the matter?
Significant, my lord, the higher qualification, lower qualification, advertisement made for lower qualification, and the candidate was having higher
The
qualification.
judgment of the
Apex Court January judgment, January.
there is nothing.
No, but the recent judgment is against, my lord, that the Honorable Supreme Court said that if the higher lower qualification is prescribed, then the government has right to eliminate the higher qualified persons because that's a separate pool. Reasonable classification doctrine is there.
Which is that judgment?
That is, my lord, that I have having not having the printed format, my lord.
You take notice.
Yes,
Human
I
right.
take. Yes,
Yes.
Item 20, need of it, 46 of 125.
Notice in both, my lord, IA and
Yes.
writ appeal.
Both men. Both. 20 also.
Item 21, need of it, 125.
20 notice we have issued.
But I have already entered appearance.
You have appeared.
Yes, madam. My name is there.
Your name is there.
Madam.
The delay of 96 days will condone.
Well, condone and the case is that this
No, we condone the delay first. Then we can entertain other things. Nothing. But
madam,
in
take care of madam.
20, the state appeal is filed
Yours
after
is 21.
No, mine is
20. The state appeal has been filed after proving a short delay of 96 days in filing. First off, application in IA number 1070 of 2025 supported by affidavit is moved seeking condonation. First off, delay is short and explanation offered is plausible. First off, no objections are filed to the application, as at either. First off, in the opposite circumstances, application is allowed and delay is condoned. First off, after 2 weeks.
But short date, I am also made ready the need short note, 1-page note. There is fee schools has been taken. It is similarly situated.
No, we
In
have
round of
to do
discrimination, it was allowed by the honorable signature. May I please? Let it come back the next week.
2 weeks. Next week we have pushed it already many people.
Date maybe. I believe.
2 weeks. It will come. If it does not come, you mention, I remember. We remember. Yes.
21, need of it, 125.
Yes.
The delay because appellant is widow also songless, one son died in the railway accident. So 9 months delay. So
Died in railway accident. When the death occurred. When accident happened, when death occurred.
Yes, madam.
And where is the evidentiary material?
Yes, madam. Annexure 4 in the read petition, page 14, 1-4. In the read petition, Annexure 4. Date of death 18/2/2020. And page,
The notice was ordered. You appear for the.
That's the first time the matter is not been admitted yet. But delay it is to be heard, and if the matter is admitted, then
No, on delay, you are not present. The notice was ordered, admission. It has come for the admission for the first time.
yes.
After 1 year.
No, Vice Madam.
it was before vacation, it was
When you come.
before vacation last.
No, this is not. This is
Since of dates.
What is the matter on merits?
Well, I'm citing before Lordship, Annexure 4, page 14, 1-4. The actual cause of death on the right side, my lord, due to dash and run over by the goods running train. Annexure 4, page 1-4.
Brother, will issue notice. You file objection. Issue notice, both on merits and on both on bill matter and the application seeking condonation of billing. First, Sri, so on our request accepts notice for your panel consent.
Not senior plan.
Senior panel counsel Sri signed sorts of notice for 14 numbers 1, 2, 3. Call after 2, 3 weeks. Yes.
Pardon to mention, my lord, item 19 and 20, as the learned counsel for the respondents have already entered appearance, may we permitted to serve the copies of the appeal papers on the counsels who have appeared instead of issuing notice, my lord.
18.
19 and 20, my lord.
18 and 20. Contact on. Just counsel learned AGA Mr. Panda permit to serve copy of the appeal memo along with application on the counsel who represents the respondents.
Grateful. Extremely.
Wish to be done within 10 days. Okay.
My lords, item 22, any other day, because I have not received the
Well, there is a delay of 720 days.
Yes, whether is seeking for the first time, he seeks adjournment. Nah, generally, he does not. Yes, all up to 2 weeks at the request of the chief. Yes.
My lords, item 23, matter is related to regularization, my lords. The usual stand is that there was no sanctioned post.
How long they have served?
Served.
What the length of service?
Pretty long, my lords, more than 2006 appointed.
20 years or over.
20 he was terminated. That termination was quashed. And there was a order for consideration for regularization. So your lordship may say single judge order may be implemented within 3 months.
Yes. Yes. Dismissed. A period of 3 months is granted for giving effect to the order of the medicine, impugned order of the medicine. Yes.
Item 24, State Appeal Secretary of 2025.
24, my lords, next week any day.
One password, my lord.
Next week any day.
Next. Yes.
Item 25, State Appeal 853 of 2025.
25 was adjourned. Somebody mentioned in first hour. 35.
Oh, this is Sukhanti Jina with the science of mantra. All of the 2 weeks variable counsel for the appellant to come and argue. Yes.
Item 26, State Appeal 1010 of 2025.
One password, please.
One password.
26 next week, my lords, any other day, my lord. Heavy matter.
Next week. Next week, if a request now. Yes.
Item 27, State Appeal 148 of 2025.
27, my lords. The impugned order was passed, basing an order in another case. WPC 2187 of 2018. Our contention is that we have challenged that order filing appeal. But the appeal number is given here. I don't find in the website. So it may be wrong.
Just looking. Because at para 5, your additional standing counsel also does not dispute the contention raised by the petitioner.
That is the order. That it is similar to that.
If appeal is filed and appeal succeeded, then we have a case. Otherwise not. Next week we'll do.
My lords, I am appearing on behalf of the opposite parties. We have entered appearance. My lords, notice
that this is a wrong number is mentioned. That's what Mr. Bevra is saying.
Yes, my lord.
Which is that writ appeal?
Yes, my lords. 1348 is what I see in the cause list. We have to check it.
And this is all approving at the request of both the sides for ascertaining the correct case number, correct appeal number. Okay.
Obliged.
Section 28, Heat Appeal 149 of 2025.
My lord, if you want
Anything is there, Mr. Nara?
my lords, let it be taken up next week.
Next, same order.
No, I am the respondent here. I was the writ petitioner. Regularization of service has been directed because I am continuing since 1995.
1995.
And
Next week we'll dispose of this.
and 2 rounds of contempt petitions, this appeal is.
Next week we. Yes.
Section 29, Heat Appeal 152 of 2025.
May please also.
Good question, Mr. Mansur. What is this matter? Anything is there?
This is relating to Secretary of the Gram Panchayat to get the benefit of pension, my lord. That the minimum pension with the interest, that is the specific order. It is at page 23. By the order,
WPC 11911 of 2024.
this is 17439, my lord.
No,
Informed order.
no, para 10.
Yes.
That order has been, this order has been made in the light of decision in that case.
In the light of that case, my lord.
Unless you take a contention in your appeal memo
Yes.
that the facts of that case are different and therefore could not have been backed upon.
Then,
This appeal is not made. You show how you are structured, what ground you have taken.
we have taken the ground in F, my lord. So far, the 123 of the GP Act, my lord. Gram Panchayat does not hold the civil post on that score only.
They do not hold civil post.
Yes.
But 91 Supreme Court says these.
But subsequently, it has been decided, my lord, because in our own High Court also, it has been reported in OLR, my lord. That was, but subsequently, Honorable Apex Court has decided they will get the.
They are civil servants. Yeah.
I should concede fairly, my lord.
They discharge the public servant and civil servant.
These are two different,
Concepts.
slightly different, my lord.
Very different. All civil servants are public servants.
But
all public servants
are not civil servant. That is the threadbare difference, my lord.
That's it.
I do.
But Apex Court in 91 or 92, I remember having read one judgment on Article 311 of the Constitution, that the employees of local bodies are civil servants. I think that decision is mentioned by Samaraditya Pal in his law relating to public service. Just look into it.
Can I check it up, my lord?
That's all.
But only that is the point, my lord, to decide.
But even otherwise, that WPC 11911.
One on in light of that, it has
been decided. But question is, if that WPC has not taken note of the section which you are now mentioning,
yes, ma'am.
Then you are right. Therefore, just look into it. Next, we get the request. Yes.
Next week it can be done.
Section 30, Heat Appeal 180 of 2025.
30, my lord, it's a state appeal.
Which is the judgment of the Apex Court. It said the people serving personnel in local bodies are also civil servants. There is one such judgment. Yes.
Section 30, Heat Appeal 180.
Here, my lord,
Ramlal.
it is Ramlal, but I am saying my humble contention is there. But these are two different because their charges are different. So far, the departmental charges are, this is also different. So this is not same and similar, my lord.
They are different.
Yes, my lord. On that score,
what was the charge framed in the criminal case? What is the charge memo in service?
Exactly. So far, the service charge is concerned. Page 8, I will invite my lord's kind attention to para D.
Page?
Page, my lord, internal page 8, my lord. This is running. Yes, ma'am. Gross negligence and dereliction in duty.
Breach of trust was the subject matter of criminal case.
Criminal case.
Gross negligence, dereliction in duty, misappropriation, gross misconduct.
Therein also 409.
They are not identical.
This is not identical.
Then take notice. Wrong law applies when both are
Same and similar, identical, I can say.
Sure. Emergent notice. Any delays there?
Well, delay is 218 million.
Both on main matter and delay application. Returnable within 2 weeks. Any contempt matter is filed? Contempt is filed?
No, I have no instance.
Next.
Item 31. E-Doctrine Policy 995/2025.
31 million. It is a payment of ex-grace. Sorry.
Yes, sir, Mr. Mantri.
It's a payment of ex-grace amount arising out of that funny cyclone in the district of Puri.
Then they have followed a
Fact remains, they have solved, but subsequently review was made and they have given the permission finding that there is a not the thatched house, it's a Pokka house which is as it is. My lord, may I kindly have a glance to the report, my lord, for a moment.
Present condition of the house, one room of Pokka house.
Yes, ma'am. This is at page 17 at annexure 2, my lord. Series of persons are there, so they have made an investigation, special, they have visited the spot and find out that.
Admitted the damage to the structure.
Yes, my lord. For that, no, there was no damage, my lord.
No, you said go to the.
Well, one room of Pokka house. He is not, he is an ineligible beneficiary. Page 17, my lord.
But where is the petitioner's signature? Your respondent's signature? These are all officials. Was it done in his presence?
Functionaries.
And you have paid rupees 10,000 admitting the damage.
No, 10,000 at the initial. Subsequently, they have made queries. Series of persons have applied for the same. So subsequently, they have gave for a special investigation. They have Tahsildar, RI, everybody has visited this spot. They have given this finding. For that, 85,100 has not been disbursed. Only 10,000 out of 95,100.
Other matters, any other matter is admitted.
Well, other matters are admitted because many matters are there. 2 days in 3 matters. Before that, many matters have been admitted. Series of
On these 3 matters.
This is item number 33 and 34 of the same district, same.
Okay. District would post similar matter along with these, list of which will be furnished by learned AG. Okay.
May I pray there is a delay. So notice will be issued on the delay by the. In 3 cases, delay is there.
Yes. Whether for this measuring, the act of God also compensation in paper. It may not be a tort. It may not be a tort. But as a state, because of the doctrine of parent patria, in that Charanjit Sahu versus Union of the Gopal gas tragedy depends.
Gopal
Sahu.
The state of this Union
gas tragedy.
Union Carbide.
Charanlal Sahu versus Union of India.
Union of India.
99. 90 Supreme Court. Just make a note and you will know. Yes.
32. E-Doctrine Policy 6/03/2045.
What is this?
32, it is regarding regularization, Miller. There is a
many years of
delay of 178 days.
So that's all it. How many months of service? Years of service?
They are since, Miller, they have been descended since 2023, since 93, Miller. During ban period, yes.
Will not interfere.
And my humble contention is, out of 887 persons, they have been selected. Subsequently, it has been reduced to 595.
Yeah.
595. These petitioners, now it is that 9 petitioners are there. So far this is concerned. They have been precluded from the list because they are being appointed under this particular ban period, my lord. So far the
which we only had argued. Ban is banned from argument. You have taken you have sucked the sweat, if not the blood of these people for how many years? It will be more than 30 years. 40
years. It is 93, my lord.
Yes.
At least 30. 40 years. 40 years.
93.
94 is 32 years.
Nothing.
That is the only condition. They have been precluded on that score.
No, that's all right. But he could have.
I should be fair to submit, my lord, to that extent.
Yes.
Grateful, my lord. In both limitation, my lord. That in the three
limitation. Yes. What is this matter?
It's this here. That's
Same.
85.
Same model, na? We made in serial number.
This is serial number 33, 34.
33.
34 and 31.
31, 32, 33.
This one. No, my lord, not 32.
33,
34.
34.
And now this one.
The 33. Same one.
এটা কই দিবি?
Then matter and this is daily application. Call along with. Yes.
36 too.
36 also same.
Same one.
37.
35, 36 same.
Yes.
My previous also.
Yes.
For regularization, he has been working since 98 for some gap. From 2010 till date, my lord, he was working as a male driver, my lord. In COVID also, he was allowed to work and he has given a permission to drive the vehicle during COVID period, my lord.
We heard this matter at one particular point.
My lord?
Did we hear this matter?
Yes, your lordship.
In part we had.
No.
Not this matter.
No, another matter.
No, Mr. Gochath wanted to file affidavit.
Who cannot find one is illegal. But there is a counter file before the tribunal.
But this was
that is annexed by one friend. That is annexed at page 142, Lordship may see. In that counter fact of the case is started from 141 itself. And this table is given for month wise how many days he is paid in daily wage basis and how many days he is working with the organization. So that detailed list we have given. So in 1 month he is having 31, 1 month is 22 days, 1 month he is getting 24 days. Like this, he is daily wage basis, he is engaged in the mail.
From 2010 until that also he had filed a counter.
and his services was taken for every 24 days.
Well,
Up to you. You never left him.
No, it is not an option to us. He is offering themselves.
In between, did you ask anybody else also to drive?
Yes, but what happening generally, those persons are regularly working with us and they don't have any objection, we are allowed to do. Because if a person is coming and getting their fees, their daily remuneration and their satisfaction, then we are not disturbing.
Mr. Padi, my brother is asking most relevant question. During his absence, did you engage other drivers?
Yes.
Show it from your pleadings.
That is, I'll give this details. I didn't have, but the officer said on discussion in earlier case, they told me it is not binding on particular driver. You can engage anybody.
But did you engage?
You have engaged.
Yes, I didn't have any.
142, page 142, which you have drawn our attention.
Yes, right.
Internal para 3.
Yes.
Page 3. See that? Not even one case below 24 days. Minimum is 24.
22?
I'm 29, 30, 26, 27, 29, 27, 28, 29.
Let's take February 14, nil. And January 14, 13.
No, you show.
On December 13, one day.
But no, the point is not that. Whether he had an option.
Yes.
Did you give an option to him to work that way?
That
You deliberately to see that he will not get the benefit of regularization. Some officers are doing this. We have seen. Maybe in the best interest of the state, they may be doing that. That's another thing. But our constitution is modeled it contemplates a welfare state, welfare of everybody.
Everybody will working on daily basis and they ultimately they claim regularization.
Yes, work it.
And we'll file the detailed counter.
Already they have filed counter, my lord. Right. They have already filed counter.
We'll file a
Maybe OPs. Call up. Yes, work it. Which is that judgment of the FX court. How matters should be treated in case of arrangements.
Your Lordship has also been pleased to pass so many orders, my lord.
Give one order. Whether where there is break in periods, how that has been treated by various courts in the country.
Yes, I will
have to give.
Yes, I will give.
Okay. Next.
Item 39.
Item 38, that is the item 38. Let's notice.
It was adjourned.
That is we tried to mention for the learned chief justice by saying that informing the exact concern of my lords. My lords, Justice, the learned chief justice said that if the matter has been listed today, just ventilate your grievances before that particular court because it has been assigned to that court.
No.
The order. All these things cannot be by oral submission.
So, my lord, I'm just making a request.
No.
Just one request. I'll leave it. Order has already been passed. I will not make a request. So, my lords, the learned counsel who's leading us has come from Delhi. So, if can it be adjourned? If it is adjourned, so we'll make submission. The order can stay. Order can stay. If my lords can only hear the counsel.
No, we cannot hear.
Direction of Supreme Court to.
You have seen 96 Supreme Court.
No, my lords.
96 Supreme Court says a bench which has no assignment is not supposed to treat the matter.
No, my lords have assignment. Say,
where is the assignment?
2025, my lords. Say the LP of 2025, my lords.
By the chief. See, Apex Court say a bench of letters patent it is. Is it not?
Yes, my lord.
Letters patent appears to be heard only by a bench comprising of chief justice. That's what the Apex Court has said. Not once. There are any number of cases.
If the matter is assigned, my lord, that is the reason why I'm saying.
No, we have already passed on. Let's go next.
If it can, my lord, be urgent, that's only request. On behalf of Rera. On behalf of Rera.
No, we have already passed the order. Yes.
Item 39. Procedure 2026.
May I please, my lord?
39. I seek time for my lord. Last option we took time.
2 weeks at the request of the
Issue notice if second time it is issued.
Yes, issue. Notice is not yet ordered.
Yes, sir.
You are appearing now.
Yes, my lord.
Already my lord is issued.
2 weeks at the request of point. Yes.
Item 14. Meet up with Sneak 1 2024.
I'm not the respondent, my lord.
Yes.
So the poor artist, he has been suffering since 1996, despite having repeated orders from this honorable court. And there is also now division, single honorable single judge has allowed the writ application, saying that he should regularize with effect from the date when the juniors, his other counterparts have been regularized. Because there are 3 petitioners for the writ application for this honorable court. 3 writ petitioners allowed. Direction was to give the appointment, but they give appointment only to 2 persons, not this person. So there are a lot of orders in content matters and ultimately he was appointed on 2000 on the consulate salary of 2000 in 2009. Thereafter, he has been now getting 9,000 rupees per month. And other person, 2 persons, they were regularized with effect from 2015. So this person, he filed writ petition is allowed. The Honorable Single Judge has directed that he should regularize with effect from 2015 when the other persons have been denied. And there are repeated orders. Despite that, my lord, other 3 occasions they have taken time.
Who appears for
my lord, Mr. Kunti earlier was appearing, but Mr. Kunti was submitting the other day that probably there is a change of panel and all that. Mr. Manoj Kunti was appearing in that day. Let's call it.
He said he would make some alternate arrangement.
Yes,
for
tomorrow, my lord.
Panel council for the.
I do not know that.
Any other panel council for the university?
Tomorrow, my lord, I will inform Mr. Khunti at that evening.
Yes, not tomorrow.
Deeply.
Call tomorrow to enable counsel for the appellant to come and argue. Okay. Possible.
My lord.
Yes, sir.
My daughter is admitted in hospital. I am in admission. Item number 19, the
19.
list over, leftover list number 1. Item number 19, my lord.
Yeah, all right. How is your daughter from?
She's in Bombay. I'm just going to, at 18:15, I'll go to Bombay.
You go now. Daughter is important, case is important.
My daughter is in, but I have come because today is opening, so I'm good.
Okay. You are like Vallabhbhai Patel. When he was arguing, he received telegram saying that wife is dead. He just saw the telegram and started further argument.
Sir, 4 cases are listed today, so I am supposed to go. Yes. Item number 19.
19.
19. Up to 10 days.
You want time?
Left to
time.
Yes.
weekly.
Weekly. Up to 10. Up to 2 weeks. Yes, sir. You could have sent words with your junior. We would have home. Yes.
Also, item 3, WDC 1099 of 2026. Item 3.
That means
How can we direct restructuring of law?
That's it. That's what we're already seeing. And recoveries and then.
So the petitioner to need to make manageable incident. But you need to assign the note of pension. He's not here. Do you have his phone number? No, it's there, na? 99375. Court is waiting for him. Help. You call him, Naveen will call other man.
Only I we have to go to.
He's over.
List item 1, date of it 897 of 2025.
Yes, sir.
Accept the weekly list, my lord. I have got a small submission. I missed the bus, item 25. I understand it has been adjourned.
Item 25.
25.
Daily list.
Today's list.
No.
It is after 2 weeks, I understand. So well, let's take it next week or this week, any day.
Next week. All right, put it next. At what next week?
25.
25 next week.
Not item 1. 25 of daily list.
Sorry. Agile. Supplement.
Yeah.
Item 1, date of it 897 of 2025.
We have to respond. Appellant should proceed.
In fact, I have a hearing for the respondent who was the Padma Shri awardee.
Respondent by non-candidate.
So 10,000 rupees cost is our levied on petitioner.
Yes, but he has not even paid that amount of money. Padma Shri award was issued, was bestowed on my client, Mr. Antarjami, Dr. Antarjami Mishra. And there is another Antarjami Mishra who is a veterinary surgeon. Based upon a telephone call from somewhere, he said that he should be the recipient, not the actual recipient. And based upon that, he filed a writ application.
Appellant is not there. Appellant is not
Petitioner is not. Appellant is not.
We can't pass order, adverse order in his absence. We can allow the petition, appeal. But how to dismiss the appeal in his absence? He will be answerable in plain.
Well, that is absolutely correct, my lord. But one sentence, Lordship permits me to say, my lord, only one sentence.
Yes.
My lord, is it the award of, or the bestowing the award of Padma Shri? My lord, can it come under Article 226? That's my only question.
2017 Supreme Court, perhaps.
Yeah.
It can. Suppose if the state, kindly see, 74 Supreme Court. I am answering question now, since you have raised that point.
Yes.
74 Supreme Court is a constitution bench judgment.
Yes.
Let it be Royappa versus State of Tamil Nadu.
Yes.
AR 1974 SC 555.
Yes.
The Chief Justice Bhagavati said, every act of the state, be it legislative, executive, or otherwise, has to be animated with reason. Otherwise, it runs the risk of invalidation on the ground of arbitrariness.
Well,
And
I love that.
the sentences.
Yeah, that's it.
I will give an extreme example. Suppose Padma Shri award is given to a traitor of this nation. A traitor, we give Padma Shri award. You mean to say citizen cannot challenge it? Therefore,
Right.
nothing beyond the judicial scrutiny. You can take it that way. We have interfered even in matters where the clemency was rejected. See that Satwan Singh versus Union of India. Clemency was rejected by the president, saying that highest court of the country has found you guilty and therefore your clemency petition is rejected. Apex court said that is wrong. Which is that judgment? This Delhi matter went to Supreme Court. You produced only Delhi judgment. Apex court said that. There the submission was, I can move the clemency petition only after highest court finds me guilty, not otherwise. Therefore, Apex court said, yes, order of the president is set aside. Petition is deemed to be pending before the president for fresh consideration. That extent we have very standard book on law of priests like V.G. Ramachandran, even V.L. Ansaria. They are saying this. Therefore, that contention may not be. But the merits, you may be having good case on merits. That's another. To enable counsel for the appellant to come and argue. Yes.
Item 2. Next week. After 1 week question.
After next week.
And next week or 1 week after?
2 weeks.
Yes, 2 weeks.
You just still you call your friend and tell
Yes, I'll
yes. Yes.
Item 2, deed of the 95 of 2025.
Yes.
My lord, kindly see page 66 and except 10. The batch of cases, similar cases.
All the appeals are required to be heard by the third judge.
Yes.
Accordingly, the deputy registrar judicially directed to place the matter before the third bench after obtaining permission of the Honorable Chief Justice. But why it has come before 2 judges? It should go before the third judge. This is the order. But if that order, it's a called bench order. So we cannot examine its legality. It has to go before the single judge, third judge.
Yes. After that,
then they can. That's what. The same order is in before us now. What they have done?
well, it's the similar case. Similar.
Was the order 59/22 passed by the single judge in contempt?
My lord, here in the series of group matters were there. It was heard and disposed of because of the dissension and report before the Honorable Chief Justice. And it was alerted to my lord Justice Ishwajit Mohanty, my lord, who was retired in the meantime. Subsequently, it has to be allotted to another person by the chief justice, because in the meantime, demonstrated the possibly wrongly taking this.
Registry to look into the operative portion of the order dated 19 February 2021 and do the needful according. Which reads as that. And do the needful according. You know, this is what it's saying.
Item 3, indicating 9 of 2025.
The Disciplinary out of consolidation matter.
Conciliation.
Consolidation.
Consolidation.
This is consolidation.
Commissioner.
But on my lord.
Fragmentation and consolidation of
Prevention of
prevention of fragmentation is here in the state.
Yes.
What of my lord? Originally in 930, when Syed Tajmul as the recorded owner.
You are for the appellant?
My lord. So this is first time I just.
What you had challenged before the Lord Single Judge?
The alienation made by some of the landlords without consent of other landlords are void, is void, and also the after death of security lands, the landlord resumed the land to his possession and inducted the petitioners as his owners. Both the consolidation officer and deputy director confirmed the same. But whether that the petition will be recorded as security or not, that will be decided by the according to sure or decided by the revenue authority. But the appellate court deputy director said it will be recorded in the remark count that the Bhagat Sutra Dakhal. That was challenged by the opposite man 4 before the single judge, before the revisional court. Revisional court allows the revision, saying that already 74 when the transfer is made by the legal errors of the security tenants is not transferable, which is not correct. 74, the security was not transferable.
Where is the order that was included before the learned single judge?
Yes, madam. That is
page number.
That is in the rate petition, madam. In the rate petition, there has been.
But here it is not right.
No, the rate petition should be entire book, na? Which should contain every pleading, every document.
Sorry. It have been. I have only annexed the judgment of the single judge.
No, under your rules. I think memo should contain the pleading of parties and
I thought that the record has confirmed.
No, we can't call for it. It has to be in the appeal. Part of the appeal. Your rules provide that.
Yes, I will do it because I mean only my pretty one is the OP number 4, in whose power the land of the record directly recorded. He has muted his name and I am trying to alienate the land.
This is of which year?
That is the year 25.
25. Has he alienated the land now?
No, he is trying to alienate the land.
No, that will be subject to list pendants under section 52.
I mean possession, but I will forcibly dispossess. That is my whole difficult.
Where is the application?
Application stay I have given and one application injunction, that is 1332 upon 226 for injunction. I filed, but it is not in board, it is not collected.
That has not come before this court?
Before the court, but it has been perhaps in the record. Because since I have filed.
So we have only one petition for stay.
Stay, yes, ma'am. That has come. Thereafter, I have filed the application for injunction.
We'll decide the main matrix. It will materialize in a narrow compass.
No, that is factors may be written so that it will be.
Why? We are hearing the main matter itself now. You argue.
Yes, I have argued. Yeah. Because the order is not there, that's why I have come the. But what happened, my lord? In 30 hour, one saw them, Tajmul was the owner of the landlord. Under whom?
This case arises under which section of which act?
Yes.
Section 9(3) of the Consolidation Act.
Right.
My lord.
Then we will go to the facts.
Yes. The petitioners filed objection before the consolidation under 9(3) of the Consolidation Act.
Petitioner filed a
objection case
before the consolidation officer.
Under 9(3) to record their names in the ROR.
It is for recording the name.
No, yes, ma'am. As under rights.
As
under rights.
Under royals.
Yes.
Royals.
Because, my lord, what happened, my lord? The landlord, under landlord, there are the 9 scheme tenants.
Just give us a thumbnail description of this consolidation act.
Yes, ma'am.
I have not seen
Section 9. Section 6 is preparation of land records.
So while the consolidation was in operation,
yes,
this objection was filed.
Yes, ma'am.
When the consolidation operation takes place in a particular area, section 4(1) is published.
Okay. These are all the fragments.
Yeah.
We want to consolidate as one single unit.
Yes.
And if you have any objection,
Accordingly, the objection was
consolidation process began when?
Section 3, under Section 3 notified. That is not disputed.
No, we want to know, no?
When was it notified?
Last time.
The proceeding begins with notification
Yes,
of
4(1).
Agriculture and Agriculture Western Consolidation Officer, Board of Revenue, charge. Consolidation means amalgamation and redistribution of parcel of land comprised in different holdings of a unit for the purpose of rendering such holdings more compact.
The area will be notified under Section 2.
Section 2 begins the process. Triggering what?
Yes.
3. Declaration and notification regarding consolidation. The state government makes it shall comply with the laws of the proceedings may be brought to consolidation operation. Issue a notification to that effect, where it shall become lawful for the consolidation officer or the subordinate or any other officer acting to enter upon a survey in connection with the rectangulation or otherwise find to take levels of any moment to clear by cutting. Where is the notification of the state government under Section 3?
Notification I have not done. Next one was the order of the consolidation officer, deputy director was filed.
The consolidation officer made the order under which section?
9(3).
9(3).
9(3) objection filed, 10 disposal, he has disposal 10.
1 second. 3. Publication of records and issue of extracts and copy of the map and additional other records which can be prepared under Section 6 together with the statement of principle prepared by Section 8 shall be published in the unit the prescribed manner according to the function.
Before that, the mayor has an aspect of all the
okay. Notices contain any person to whom a notice of the subsection 2 has been sent, any other person interested may.
So, Section 10 is the conciliation. Section 11 is the contested case.
Filed before the consultation of the objection on the correctness of it. When 19(2) notice was issued, shows.
19(2).
Yes, because your objections are 9(3).
Yes, ma'am.
They are preceded by 9(2).
Yes, ma'am.
I'll show that 9(2) when it was issued to him.
That has not been annexed, but
you tell me that you have filed within 30 days. Where have you stated?
Well, that was not disputed at all
in your opponents. You can travel to 9(3) provided 9(2) proceedings are held. Where are the 9(2) proceedings? And law prescribes a period of 30 days for that.
84, 93, 93 application was filed. 84.
In 1984.
Yes, Lord. 3721 of
93. You filed it on which date?
Date, order was passed. Oh. Order was by 3-6 and
Sir, we'll give you 1 week time. You turn pages at your office and come back. We are not happy with this kind of purpose. Kindly go through the paper. We'll give you a short date.
Then 89 the order was passed. 89-93 order was passed by the consolidation officer.
No, you said that you filed 9-3 in 1984.
Yes,
in 1989, the order has been passed. But the first question is that after the publication, when did you file? Whether within 30 days or not?
Within 30 days, because the matter has not been objected by anybody.
No, we are section says it's an injunction to the court.
Yes.
Any limitation period where the law prescribes, it is an legislative injunction to the court not to entertain the grievance. Section 3 of the Limitation Act.
Yes, ma'am. I follow.
Whether objection as to delay is taken or not, court shall not entertain a delayed grievance. That's section 3 or 4? 4. No, sir. You just prepare a small note that will help you, and maybe it will be helpful to us also.
All right.
All right. 1 week you need. Can we call it after 1 week?
Yes. Only because I am apprehending the land to be sold by the.
But you have to impress the court, na?
But that was not raised for anybody.
So now we are raising that.
No, now I will understand. Because it was not raised by anybody.
These are all agrarian reforms law.
That is right, my lord. Because it is not raised because of the fact that it is not before any authority. Even before the single judge. It is not raised. That's why I was not in a position.
This is an appeal. This is an appeal, na? Is it appeal?
No, appeal, yes, ma'am.
I think is open to the appeal.
I do understand, my lord. That's why my only predicament is that the opinion 4 is now trying to alienate the land. That is the only status quo we made it till now.
All after 2 weeks. In the meanwhile, parties are directed to maintain status quo with regard to possession of the land in question. That's why status quo. So that in order to dispose of that, there is no problem. Yes. Up to 2 weeks.
In Delhi?
Yes, sir.
Yes.
Number 3.
So,
For this 10995 of 2026.
so installment gratuity payment.
Installment. How can we entertain your request for installment? We are not investors.
Sir, to restructure କରିବା ପାଇଁ ଚାହୁଁଛୁ।
No, the right to restructure is a justiciable right. What Bafna says, in all matters like banking, these courts are not supposed to interfere unless you show law which permits intervention. Whether loan should be given, what should be the rate of interest, how many installments, how to recover, whether restructuring of the loan can be done or not. These are all banking bills. How good can you not do banking business at all?
Time କିଛି ଦେଇଥାନ୍ତେ payment କରିଦବୁ sir banking.
You want some time?
Yes.
For payment?
Yes.
For payment?
Yes.
How much is due?
Sir, 1 lakh above.
Where have you met?
Only 1 lakh.
Sir?
Only 1 lakh.
Yes.
Show that. Sometimes smallness of the amount will give a big ground.
ମୋର 20/26 ପର୍ଯ୍ୟନ୍ତ ବାକି ଅଛି।
No, that is all right, but where have you mentioned it? The statement is there.
Yes.
Which statement? Annexure 1, Annexure 2.
The statement page is
No statement, but where from will you find it?
You show only 1 lakh rupees, just shows. The account statement from 12/6/2000 to 12/6/2025. For 25 years, they have given the statement. Where is that amount which shows you have borrowed how much money?
outstanding, sir.
Where is that? Which particular?
So page number 10.
Page number 10.
Sir.
Which one? Page number 10. This is a statement which starts from 20th of July 2023.
So,
giving the details of your deposits up to 20th of May 2025.
What is the outstanding amount, brother, now?
Nowhere you have mentioned neither your application nor the document.
The Axis Bank is scheduled bank.
yes.
How repetition is maintained?
Sir, problem also the statement, sir.
No, problem is all right, but how can Reserve Bank of India
And you have implemented arrayed Reserve Bank of India also as OP3. Why Reserve Bank? If happily you have not added World Bank.
What is the relief against RBI?
Relief and payment for a multi time.
Payment, nothing has been mentioned. Your application is completely silent about the quantum of loan you have held. What was the scheme of loan?
So vehicle loan.
That's all right. But what was the scheme of loan? That vehicle was hypothecated to the bank.
It is 84,99,213.
Set out with vehicle loans, the tie up with person.
Tie up? With whom?
With a home loan versus a vehicle loan.
Along with vehicle loan, there is a home loan.
Yes, sir.
Home loan.
84 lakhs.
84 lakhs.
84,99,213. That figure you will find at the internal page 3, running page 3. What you want us to do now?
I need to relief from bank.
Relief from bank?
Yes.
Bank is troubling you. You want moksha from bank now?
For which time the payment
He wants 4 weeks time to make the payment.
You will make the payment?
Yes.
Within 4 weeks?
4 weeks.
How much payment you are making?
50% payment for
50% of the outstanding?
Yes.
Including that personal loan?
Yes.
Home loan?
No.
You take notice.
Notice
And you will call it day after tomorrow. You will take dusty. What do you call it? Dusty. You take notice. Okay. We'll call this matter on Thursday.
Yes.
Right? Issue the petition prayer reads as under. Next paragraph. Counsel for the petitioner submits that his client is ready and willing to settle the loan amount if a reasonable period is prescribed by the court. First off, he also submits that his client is a bona fide borrower and he would make 50% deposit payment of 50% of the outstanding amount, including the personal loans. Personal loan. First one. Next one. In view of the above, issue emergent notice. In addition to that, petitioner is permitted to take the first of registry to facilitate the SIC. First of call this matter on first day instant 25 instant.
May I please your lordship?
Silence made us to pass some order. Sometimes by arguing we lose. By being silent we gain. Yes.
My lord, may I please you, my lord, item 19. Item 19. Item 19.
Namaskar. My lord, namaskar. I am the appealing myself here. Namaskar. Sir, the read appeal 1729/25. I have filed for getting higher gratuity. The bank has released less gratuity. The gratuity has been enhanced to the 15 lakhs, my lords, from 1 January 2016. I have retired from the bank from 31st January 18. Our service rule provides we are entitled to greater gratuity at par with the government of Odisha. But in spite of my repeated request prayer, that was not considered by the bank, for which I have taken in the REIT petition 293301 of 22. I have submitted prayer, but that was not considered by Hon'Ble single bench was kindly to pass order to submit written argument in Odia Bhanna Kodla. I have submitted everything on 3rd December 24.
No, where are the full stop? There is not even a comma in your statement.
Sir?
No comma, no full stop, no semicolon, nothing. You appear to be express bullet.
No, sir, I beg apology, sir.
No, it's all right. No problem. But we should understand, after making one statement, you have to give some time to us. We are not Aristotle.
I beg apology. Sir,
okay. Yes.
Sir, the gratuity was enhanced to the tune of 15 lakhs.
All right. Who is your company?
Sir,
who is your company?
Sir, bank, respondent number 3.
Bank, cooperative bank.
Cooperative bank, sir.
Who appeals for the cooperative bank?
Mr. Rath, A.K. Rath.
You are also party, Mr. Deora. 1 and 2.
My lord, sir, 2 is management of district central cooperative bank.
No. Registrar Cooperative Society.
My lord.
You are representing them.
My lords, 1 I represented.
1 and 2. Collector
is there.
2 is acting administrator of the bank. So bank is to appear.
No, administrator. He is appointed by the government. Under particular, that's how Karnataka Cooperative Society is acted.
Yes.
Here also you must have, because they have a common pattern in all legislations. Yes. So 1 and 2 you will be appearing. Even if he is administrator, you have to appear.
My lords, actually, the management of cooperative bank.
Of the bank, because management is not there.
Yes.
He becomes the management. So you take notice for 1 and 2. And 3 notice has to go.
Man.
If the chief executive officer, even after the administrator is appointed.
It is.
What's the scheme of the act? I do not know how your state act operates. No, notice is not yet ordered. They put in publication.
One order was there. Notice. Copies of the petition. Copies of the petition to be.
Order dated 28 January. In fact, your lordship directed AGA to accept
For OP number 1 to 3.
Sir, I beg apology. Sir, B side Lawrence Advocate has appeared perhaps on behalf of respondent number 3 and respondent number 5, respectively. B side, namely Lawrence Advocate, it has been mentioned in the cause list, my lord.
By the your lord.
We have ordered on 28/1/2026. January 26th, no? Thereafter, who appears for R3? OP3? OP3?
The appellant is telling that Mr. B. Sahu.
173.
Where is the order of the learned single judge?
Page
Sir?
120.
No, so kindly leave your hands, be free. You need not hold your hands folded.
Page
123. Annex 12.
Yes.
123.
Yes.
Counted from my map is there from 7:15 to 15 minutes.
No, why are you challenging this order? Which order you are challenging? You are an employee of the bank.
Sir, my lord, I was the employee of the bank.
Huh?
I was the employee of the bank. Sir, read petition through 29301 of 22. That 15 lakhs was not enhanced in spite of my repeated prayer, sir. My lord, that was and the rate of interest was 18%. That was allowed 6% only.
By which notification it has been enhanced to 15 lakhs? According to your application also, initially it was enhanced to 10 lakh, which the bank had agreed to pay, but you did not accept.
Sir, my lord, in the meantime, that was enhanced. Which was
This
not on,
is of 2021.
Correct.
so that was not in my knowledge.
Was in 2021 for 10 lakhs. And it was paid to him, he did not accept. He said that it is not 10 lakhs, it is 15 lakhs.
Interest awarded.
So he did not accept it.
Sir, bank is the noble employer. He is to implement it.
And now the single judge has only
Learned single judge has allowed interest in his favor.
6%.
Yes.
That perhaps we may enhance. That's another thing.
My lord, he is not challenging that. He is challenging that. He is telling that he is entitled to the enhanced rate, which was enhanced in 2021.
When he
retired in 2018.
Whether that enhancement has got a retrospective effect?
No.
Where is that instrument?
Sir,
How the enhancement took place?
sir, I beg apology. 1 January 2016, it was came to effect.
Which document? Annexure?
Which document?
Sir, annex, I beg apology. Annexure 7, page number 80.
Wait.
Page number 80.
79. 7. Sorry.
7 Central Pay Commission.
No, sir, not central, state it is.
Pension, family
Seventh pay commission was 2016.
2016.
And the retiring this is provided the maximum limit of retirement gratuity and death gratuity shall be 15 lakhs. But in time, the rates of payments of that gratuity shall be realized.
Shall be. Word used is shall be.
Retirement and death. So less than 1 year is 2 times the monthly emolument. 1 year and more, but less than 5 years, 6 times monthly emolument. 5 years and more, but less than 11 years, 12 times.
No, this is for central government employees. It says, this memorandum itself says, it is for central government
So
employees.
you have worked for more than 20 years.
Sir, 38 years I have served.
30 years. So,
But how you are a state employee of the cooperative society?
Sir,
Bank.
that is scheduled bank it is. That license holder for Reserve Bank of India my lord. Then
But
it is
make you an employee of the state, the central government. Kindly come to page 17.
state government notification is state governments, my lord.
Provisions related to the computation values, the limit of participants.
Finance department to state government.
You are employee of the state government.
No, sir, we are employee of the cooperative bank.
Cooperative bank.
Cooperative bank, my lord. Sir, it is in service rule, it is page number 86. Gratuity, it has been stated that every employee of the bank shall be entitled for payment of gratuity as per provision of a payment of gratuity act and with the Odisha payment of gratuity rule 1974. Sir, my lord, in the meantime, government of Odisha, that Department of Labor has also sent letter which is I have enclosed in page number 84 that the cooperative bank is not implementing the gratuity rule and on the correspondence of the General Secretary, which has been stated in subject that non-compliance of provision of payment of gratuity act 1972 and Odisha payment rules 1974 by central cooperative banks requesting for penal action under section 9 and 11 of PG Act 1972 and against the defaulting CCB. Sir, page number 84, my lord.
You are from which place?
Sir, Noyagada.
Can you come here?
My lord, if order will be passed, I will go.
What order we should? We will only say if you come, we will take up your matter.
Sir, I will go because I have faced one accident for which both joint of knee have been displaced. I have a retired, sir, my lord, 8 years, more than 8 years and 5 months. Anyway, I will go for submitting prayer personally.
He said that the government has also directed.
Sir, maybe my prayer is maybe fixed to 2 p.m. or something. Sir, 8 years I have retired.
Then come to
My lord's
page number.
page 1784.
Come to page 84. No, he is not in a position because he has met with an accident.
My lord.
My lord, I will go.
In fact, bank has their own counsels, my lords. Mr. Baidar Sahu generally appears for the bank.
Is it?
Yes.
He has also entered his appearance. Name is reflected in the cause list also.
Chiefing. The mobile number of that counsel is here. You keep one telephone instrument here. So that we only will call them. If he does not come, at least he should argue over phone. Central Cooperative in the state of Orissa. Just give call to me. Your matter is going on, some adverse order is being passed against you. Just tell him.
Well, let it be pass over by that. After lunch, we can communicate.
To come after lunch. Right. Sir, you come after eating lunch.
My lord.
After second session.
My lord.
What's up?
Item 5, date of page 1789 of 2025.
Why that lady along with child is waiting? Just ask why that lady is waiting in the court with the child. Why are you waiting, madam? Sister, why are you waiting in the court? You have nothing to do.
Oh, they are plus.
Yes.
May please, madam.
Item 5 minutes. I am for the two. I have filed the faculty now. My name is reflected in the cause list.
But you are here.
I am here because of my item 9 is there. I just come to know it is there.
Register to print the name of counsel, say so and so as appearing for OP2. OP2. Post this matter next week.
Yes, both the matter.
My lord, there is little development for which I am to file an additional affidavit. I am filing and I will serve the copy.
Okay, in the meanwhile, additional affidavit may be filed. Affidavit stroke additional affidavit may be filed by the consent party after serving copies thereof on the others.
Serving the copies right now.
Yes. File it in the court. This is not registered. Yes.
Take it up tomorrow.
Tomorrow. Why your astrologer has said tomorrow is a good day, auspicious day.
File is misplaced.
Huh?
File is misplaced.
File is misplaced. All right, day after. Yes.
This item says this is 192.
Yes, Mr. Mantri.
Here, my lord, the short question which falls for consideration of your lordship is whether inter-se seniority can be fixed, adheres the prescription available under the rules, as well as adheres the merit position shown in the list, merit list prepared by the examining body in the direct recruitment. My lord, what has happened in the present case, the commission, who is the examining body, has prepared a merit list where my position finds
serial number.
My position is just 1 minute. My position is at serial number 263, whereas
1 second. 263.
Whereas
now those who were below you,
yes,
are they given higher ranking?
Yes, that is the gradation. When the gradation list was prepared, they were placed above me. That gave rise to the cause of action for which I made representation. Thereafter, approached this honorable court. Now, my lord, the honorable court has passed an order without looking into the rules and without going into the aspect that in the merit list, which the honorable court himself has referred to, my position is placed above.
Who appears for the other side?
My lord, it's a fresh admission.
Fresh admission.
It's a fresh admission.
Because Apex Court say in the select list, whatever ranking is assigned, ordinarily that position has to be maintained in respect of those whose names figure in the list.
Yes.
Unless the rules provide for a contrary position.
And at the same time, it must be qualified.
Yes,
if
ma'am.
it is qualified.
Yes.
If it is not on merit.
Yes, ma'am. It is, well, we both opposite party number 7 as well as me both appeared as a direct,
same examination,
direct
same
candidate.
Then,
and my position is higher up. But still, my lord,
you are given lower rank.
Then even recently in Jharkhand case, Honorable Supreme
Court has said that.
I have referred to judgments. That is also part of my written note of argument, which is there. But still, my lord, I was not favored.
We'll issue notice if you permit us.
Your lordship,
issue emergent notice to OP number 6,
7, sir.
6 and 7.
Go, please.
5.
First off, Mr. Mohanty.
Not 5 also.
No, 5 is there is a one standing counsel, na?
Yes.
Standing.
Mr. Mohanty, learned AG is requested to
1 to 4.
is for 1, 2, 3, 4, 3 and 4.
Yes.
First off, who is the staff selection commission?
No, there are panels.
My lord,
Mr. Patna, Suryapurna.
No, senior advocate cannot take.
Sanjeev Swain.
Issue emergent notice to OP number 5. 1, 6, 7. Learned AGA, Mr. Mohanty accepts 1, 2, 4. 1, 2, 4. First off, matter lies in a narrow compass and therefore post it up to 3 weeks. Okay.
Notice in the notice. Because on the basis of that, my lord, in subsequent promotion, I am getting now
short matter, na covered by judgment.
Your lordship, any action taken in the meantime shall be
any action taken in the meantime shall be subject to outcome of the appeal.
Okay.
Item 8, Miller. It's a state appeal. Though similar matters has been disposed of because that Nityananda Vishwa which has been carried out to the Honorable Apex Court so far this period of pension is concerned. Let it be tomorrow or day from now, I will collect that copy and provide us by the date this.
Yes.
Tomorrow or day after?
Tomorrow, not next week.
Not next week.
Next.
Item 9, usually item 9.
So I am from the appellant, my lord. So notice has already been issued in this case. My lord, the honorable single judge is passing the order not giving any opportunity to this appellant, my lord. So I have, in fact, the petitioner respondents herein has not made us a party challenging the order where we are the contesting party. This is the limited question, my lord. No opportunity, no notice, and the first day of listings, my lords, the order has been passed. I am directly affected being a temple deity, my lords.
You are a temple deity?
The properties of my lords deity are affected.
Deity is not heard in the matter?
No, not made a party. Not made a party.
Not made a party at all.
And I come to know when a contempt proceeding was initiated and the Tahsildar sought suggestion from us. Thereafter, we challenge this case, my lords.
With the leave of the court?
Leave of the court. I filed the leave of the court and notice is issued.
You could have filed petition for reviewing this order.
I could have.
Right of Shivdev Singh.
Shivdev Singh judge.
Supreme Court. Supreme Court.
64 minutes. Yes.
64.
Yes. That is the only judgment. Subsequent date can be filed reviewing the order of the where we have not given the opportunity.
No, what Apex Court is AR 1963 Supreme Court 1909.
Yes.
Says where a person not being a party is made to suffer by virtue of an order, he should file writ petition seeking review of that order.
Yes, ma'am.
You do that. We'll permit you to do that. Because that judge will be knowing. He will have an advantage because in fact, already has seen the papers.
The judge has been retired by the time.
No, question that. Even if he has retired.
Some other court
said like this. So one paragraph, I just read it.
So it can be reviewed, read can be reviewed, making us a party. Actually, the respondent is not here. Just suppression of material fact.
That also you can take up.
There is a judgment, order of the Honorable Supreme Court remanding the case to this Honorable Court.
In the self-same matter.
Self-same matter, and the same party, the Mahatij party.
Supreme Court has already interfered and remitted back.
Remitted back, and that matter was also dismissed, filed by this Mahanto, the respondent herein, madam. There is lots of.
Will issue notification.
Issued his appear. Yes. He is not here.
Name is reflecting.
Name is also reflected. This can be set aside and.
This is absent. Really not come to your office in the evening. Please, brother, you have second order in my absence.
Let's call this matter next week.
Call this matter next week to enable counsel for the respondent to come and argue. First off, we have noted that the matter lies in a narrow compass.
Can it be comments in regular list? Regular list.
Put it in regular list.
Much obliged.
Which is that judgment? A deity in Hindu law is a person, legal person, and therefore it should be heard, which is the pre-council judgment.
There are lots of judgments and minor.
We don't want to take balance in our hand and way.
Even if the DT is any person can represent DT matters. A Gopal Krishnan case in Supreme Court. I have cited in this case also the 3-4 judgments. Those judgments have cited matters.
In that particular paragraph of Justice Chandrachud's judgment in Ayodhya judgment. Yes.
Utilist item K, reduction 1 from 95 of
Yes, sir.
Counter has not come, my lord. I have filed my counter on 31/3/26.
Counter has not come.
No. I have taken up along with my counter 1 week after one.
Yeah, in writ appeal also counter can be filed in your court.
Yes, ma'am. I have filed my counter on that. I am for the respondent number 1.
You have filed counter in the WP. In WP.
In WP, I am the appellant.
You are the appellant.
Yes. He was the respondent, complainant.
The order of the
He was challenged the order.
Have it week after next.
Yes, ma'am.
any day I am ready for the hearing.
You ready?
Yeah, there is delay of about 14 days, man.
Will condone delay.
Yes, ma'am.
Appeal is filed after condoning a short delay of 14 days. And application in I number 3672 of 2024 supported by affidavit accompanies the memo. First of delay is short and explanation offered is plausible. No objections are filed to the third application, rightly. First, in the above circumstances, application is allowed and delay is condoned. Okay. First after 3 weeks. Next.
With regard to SR noting, stamp paper, SR noting that the opposite party number, appellant number, respondent number 3 has not appeared, SR has not been completed. This is the dealer of the truck, man. They are not required at the stage of hearing. If required, your lordship may issue notice on that. That may kindly be deferred, the notice against the dealer.
But he is a party.
He is a party, my lord.
How can you defer if he is a party? If we defer notice.
No, my lord.
No, adjudicator.
No, sorry,
Let notice go. Notice to OP number, response number 3.
3, my lord.
3. Returnable within 3 weeks. Okay.
Fix of date, man.
Repeat it within 3 weeks.
My lord, for the other side, can it be taken next week and not well?
Next week. Your objection.
The meantime, I will
For 1 week also. Suppose if he objects to your passing over, what will you do? You have it next week. You want something there, na? Call next week at the request of. Yes. Yes, sir. Your friend wants 1 week time. Any urgency?
Urgency that he is out of job, yours, since long. Class for employee.
Sir, next week finally.
No.
Do not seek any other. Class for employee. We'll do it next week.
Yes.
Next week finally at the request of. Yes.
My lord, a state appeal involving 128 days of delay, Lord. 128 days. Lordship, kindly issue notice because.
Any ground?
Ground because, Lord, rules, specific rules have been violated. The post was not sanctioned and not approved by the government. And the Honorable Single Judge has stated that even there is a violation of rules, you pay the consequential financial benefits. My Lord, Lord and Counsel has already appeared, Mr. K.K. Swine and others. I will serve copy on them. Let it come in the other day. On merit, we will argue because we will show the rules to your lordship that what rules have been.
Week after next, at the request.
Well, we'll serve copy, my lord. That observation.
The 65 days delay is there.
That is item number 13.
13. This is 128 days.
128 days.
Opponent is not here.
No, not here.
No.
No objection has been filed because notice has not been issued yet.
No notice is issued.
No notice.
But their name is shown.
But they have advance. In advance, they have appeared. So, thank you. In advance, they have to
issue notice. First up, since counsel for the respondents has already entered appearance, no formal steps be taken. First one. Appeal is filed after booking a delay of 128 days and an application in I number 6889 of 2024 is moved, seeking its condonation. First one. An affidavit is also attached to the IA. First, delay is short and a plausible explanation is offered for the delay proved. First, there are some arguable points in the appeal as well. First, throwing out such an appeal only on the ground of delay would not do justice to anyone. First, after all, condonation of delay would not add merits to the appeal. First, in the above circumstances, application is allowed, delay is condoned. Okay.
We'll serve copy on the land promises.
Okay.
After 3 weeks.
Yes. Next.
Case item 30, read appeal 2686/2024.
My lord, in this way, straight away, I draw your lordship's attention to page 89, where the impugned order, and 90, the next page, 90. Para number 6, your lordship may see that considering the submission, this court is inclined to quash the order passed by the opposite party number 2 and annexure 19. While quashing the same, this court remits the matter to the opposite party number 6 to take a fresh decision on the claim of the petitioner to get the benefit of the reinstatement, relying upon the Ramlal case. If the Ramlal case is covered, is applicable here, then we are entitled, we will give a fresh decision. On that count, I concede that I seek your lordship's observation that we will take it for fresh.
Appealability.
That's I concede. Therefore, I draw it straight away the attention. With all contention may be kept open, we will pass the necessary orders. If it is covered by the Ramlal, we will pass the necessary order.
And also, a recent decision, another decision to this court covering my case also. Another decision that is my lord.
No, he is very more than fair to you.
We have the rational consideration we are out of employment for last 2 years. Consideration only. They have to file appeal and the matter delayed.
This intra-court appeal by the state and its functionary seeks to call in question a learned single judge's order dated 24/6/2024 entered in respondent employees WPC number 14723 of 2024. First, the paragraphs 6 and 7 of the order, impugned order, read as
6 and 6.1.
6.1. 7 also.
7 is the formal.
Because they have said taking fresh decision, the decision of Ramlal. That's the input. Next one. Learned, kindly be seated. Learned DGA Mr. Panda, appearing for the appellant mentally surveyed that the learned single judge could not have granted the leave to the respondent employee by quashing the order dated 7/6/2024 made by the appellant number 6 at annexure 90. He also disputes invocability of decision of apex court in Ramlal, which is founded on the principle of honorable acquittal in a criminal case, in which a criminal case. Next one. Learned counsel appearing for the respondent employee, kindly be seated, vehemently resists the appeal, contending that the impugned order is absolutely innocuous, inasmuch as learned single judge has remitted the matter to the portal of jurisdictional authority for taking a fresh decision in the light of apex court ruling in Ramlal, and therefore appeal of the kind is not maintainable at all. First, he also adds that since all contentions are kept open, it is ununderstandable as to how the appellant state is aggrieved by such an order. First, we agree with this contention. Next one. In the above circumstances, this appeal being unworthy of merits is liable to be dismissed, and accordingly it is. First, however, we make it clear that all contentions are kept open for being considered at the hands of appellant number 6.
No.
Who will reconsider?
Yes, appellant number 6. Block education officer, not
my lord.
Jurisdictional authority.
jurisdictional authority, because that was option number 6 there.
Yes, I have not 6.
This exercise to be undertaken within an outer limit of
8 weeks, 8 weeks.
8. Delay, if proved, will be viewed very seriously in the next level of the legal battle. Okay.
Well, item number 14 and 15 may lie over to be taken up tomorrow, my lord. Because I'll come prepared on that.
Tomorrow in the supplement list.
No,
Tomorrow supplement list.
it is already in the list. Your lordship will be taking up these matters.
Tomorrow we'll take 14, 15 only. Now other above matters are disposed of. 11 matters are for the day after. 9. And Thursday? Yes.
Last day in supplement list, my lord.
That is the supplement.
Okay. You'll come back?
It is taken to the supplementary list or it will be called from the weekly list, my lord?
No.
Supplementary. Date. Accordingly,
Special Court. It will be 1729 of 25. My Lord, namaskar. My Lord, namaskar.
No. Why it is?
Because we told him to come.
Oh, Uncle Lance, because that's it. Yes. He has to come.
You were cooperative. Bank's lawyer is here.
No, my lord, I am private party. Opposite party number 6. Ex managing director of OCB. No application against me. No prayer against me.
You are still made a party.
Yes.
But where is that person, the lawyer who represents the society?
Registered cooperative.
Registered government.
One government.
One to government.
Yes.
Where you are not there now in the. Who are you?
My lord, I am respond number 6.
No, there are only 3 respondents in.
Yes, total 6.
Excuse me, another writ appeal is 1731, where respondent number 6 is TK Panda. On whose direction I got.
In companionment.
173.
But where is the council representing the society? No, they can't represent because now there is administrator.
That is
there is one section in Karnataka Cooperative Societies Act. Administrator functions as the managing body of the society. I don't know whether such a provision is there in your act. There must be.
That is how it is.
Administrator appointed when the board is superseded.
Mr. Behra, then it is in the you are the answering party. Because you represent the administrator. You said you are not. You just verify and come back.
My lord.
We'll have it next week. All this matter. Give something.
My lord, excuse me, sir. It may be fixed at 2 p.m. I have been retired 8 years since and suffering from various disease.
We'll have it.
Okay. 1731 is there. May kindly order 2 o'clock.
First July 2 o'clock.
First July 2.
Oblige. High office.
Yeah.
Previous item 16. May please leave on 8 of 2024.
May please do losses.
Yes.
In this case, there is a delay of 165 days, but practical matter, the writ appeal was filed in time. But inadvertently, the authentication fees was not paid. So it was dismissed. It was not brought to our notice. It is mine.
What is the merits?
Merits, my pensionary benefits. Original pensioner filed the petition before the administrative tribunal for release of his pension and other pensionary benefits, gratuity, GPF, etc. There was an order for release of the GPF pending because the state has not filed any application. So they have state administrative tribunal passed order to release the GPF, but it was not released till date. Pending this, my lords, the state administrative tribunal was abolished and the matter was transferred to this honorable court. And in the meantime, my lords, the original pensioner died and the widow, daughter-in-law, wife is predeceased, the pensioner. Two sons, they are predeceased. And one of the widow daughter-in-law was substituted, and it was order was passed that it is to be decided by the civil court and go to the civil court by the honorable single judge. But my lords, here, first, my lords, as per the decision of the Supreme Court, all pensionary benefits are properties. And the provision, Orissa Administrative Act, debars any suit before the civil court. It is only to be entertained by this court's minds. So, my lords, since widow daughter-in-law is one of the legal heirs, so she has applied, and my only submission, the matter may be decided on merits.
If Puppet's court say pension is a property,
yes, my lords,
then it becomes a property dispute, not a service dispute.
But it is a pending, my lords. But it is pending. But irrespective of anything, my lords, it is a pensioner benefit, my lords. And the case was pending since 2018, my lords.
When wife died and children died?
Children, their wife predeceased the pension holder. Wife and sons predeceased the pension holder.
How?
My lord?
Why they predeceased? What's the cause?
My lord?
What was the cause that they predeceased? Was there any disease?
Any
Yes,
accident? Or what is
In normal case?
No, not normal. Sons are how it can be normal.
No, but it appears that so many people of the family have died.
Yes, ma'am.
And predeceased the pensioner.
Yes, ma'am.
So that is why we put to you that what is the ground on which you say that these sons have also died. You have procured the documents.
I filed the affidavit, my lords.
No.
Your lordship says that the documents.
Death certificate.
Death certificate.
But death certificate.
Death certificate.
Cause of that, it will only show.
We want to know. Because there is a law.
Yes, ma'am.
Suppose if somebody kills the LR, then that somebody will not.
It's not. It's not a case. It's not a case. It is because of the disease.
Want to know.
It's because of the disease.
We want to know.
Yes, ma'am.
Why is the wife died, children died, subsequently the pensioner dies.
All are out of diseases, ma'am. All are out of disease.
No, you are saying it only out of from what basis you are saying?
It's my information, my lord.
Then you enter witness box, will cross-examine you.
File affidavit. File affidavit. What is the cause of death or?
You have to say that. Because suppose the person now who seeks substitution has something to do with the death of these people, then we will deprive her. We will not give any.
No. It's not a case, my lords.
Maybe.
If your lords desire to file affidavit.
You file it.
File affidavit.
Appellant or petitioner?
Appellant, man.
Appellant to the daughter-in-law of the
yes, ma'am. One of the
daughter-in-law of the deceased employee to file an affidavit explaining the circumstances in which wife and children of the deceased, predeceased person. This to be done within 2 weeks.
Affidavit, ma'am.
If done, post the case. Otherwise, not.
English Title 70, Legal Bill 76 of 2005.
And your lordship, it's a state appeal. There's a delay of 231 days, your lordship. This is
on merits.
On merits, your lordship, this appeal has been filed against the order of a single judge, whereas it has said to release the area salary, your lordship. But this person has been, but there is a pending of DP, his department proceeding. He had challenged in a writ petition that is also pending. Lordship, the fact is that he joined as a lecturer in English in the year 2000, your lordship. In the year 2000,
2002.
Your lordship. In the year 2000, your lordship. And on a certificate where he, on a fake certificate, your lordship. An inquiry was conducted on an allegation, your lordship, that is at page 17, your lordship, of the writ appeal, your lordship, wherein it has been inquired into, and he had substituted his marks to get an aggregate of 56.50, your lordship, so that he would qualify as for the post of the English lecturer, your lordship. That has been found to be fake. His actual marks state that
he gained entry to the service
in the year 2000, your lordship, 12/12/2000, your lordship. And he has actually secured 412 out of 800. That its aggregate comes to 51.50, your lordship. But he has given a fake certificate where his aggregate is showing to be 56.50, your lordship. Yes.
How many marks he has shown?
He has shown, your lordship, he has manipulated his mark sheet, and he had got 48 and 43 marks in paper 1 and 3 of respectively in MA English examination in the year 1998, your lordship.
This you came to know when?
This, your lordship, it was in a Sunil Kumar, your lordship, That was inquired into 22/11/22, Your Lordship. The government, that is page 17, Your Lordship, Annexure 2.
22/11?
22.
2011.
Yes, Your Lordship.
22/11.
22/11/2022.
November.
November. 22nd of November 2022.
So by then he has worked for 20 years.
For 2 years, Your Lord. 22 years, Your
22
Lordship.
years.
22 years.
Yeah.
How can you do it now?
An FIR was filed, Your Lordship, on 18/9.
But all these years he has worked.
He has worked, Your Lordship.
He has worked.
Worked.
What happened to inquiry?
Inquiry also, it was found in page 17, Your Lordship, that it was a fake certificate, Your Lordship. The certificate was inquired into by the Vice Chancellor of Deputy Controller of Examination of Sambhalpur University. He verified the mark sheet that it has been manipulated, Your Lordship. And a DP was instituted against him. He has challenged the DP in 5679 of 2024, Your Lordship, and that is pending, Your Lordship. In the interim, Your Lordship, he has filed for the area salary from the year November 2022. 22nd of November 2022, his salary has been stopped, Your Lordship. Now, the disbursing authority is the Deputy Director of Higher Education, Your Lordship. And in that petition before the Honorable Single Judge, he was not made a party. Appellant number 2 and 3, they are not the disbursing authorities, Your Lordship. And neither have we even filed a counter, Your Lordship, in that petition, Your Lordship.
No. Is he put under suspension?
Your Lordship, the DP has been challenged and it has been stayed, Your Lordship.
Stayed.
Yes.
And he's working.
He's working, Your Lordship.
How can you stop the salary?
But the order has been given to appellant number 2 and 3, who were the person who disburses the salary, Director of Higher Education and the Deputy Director of Higher Education, who have the power. They will not meet parties therein.
No, that's not it.
Yes.
Question is not that. Question me, where a person works, can you deny wages to him? That will be contrary to Article 23 of the Constitution. Article 23.
Illegally he's working.
Article 23 enacts doctrine against beggar. The word beggar is found in Article 23, though it is not a word in any English dictionary. Beggar means not depriving worker of the wages, full or part. In Sirwai's constitutional law, he has dedicated 2-3 pages on that. So once he works, even those who work in prison, the serving sentence-serving convicts, they are to be paid the salary, wages. This is what Apex Court said in the state of Gujarat versus Hon'Ble High Court of Gujarat. 96 Supreme Court, 95-96 Supreme Court. Go to that judgment. High Court of Gujarat versus State of Gujarat, or State of Gujarat versus High Court of Gujarat. There is such a judgment. State of Gujarat and another versus Hon'Ble High Court of Gujarat. This is AR 1998 SC 3164. Apex Court said, even the prisoners who are serving the sentence, if they are made to work in the prison, they should be paid the wages. If that is so, how can you deny the wages to a person who is working, who has worked? You remove him from service is another thing. You can't say that you will not pay the salary. Because admittedly he has worked.
He has worked.
For worked period, you cannot say that. Section, we don't use. The state is in this in this intra-court appeal seeks to lay a challenge to a learned single judge's order dated 24/4/2024, whereby respondent employees WPC number 5733 of 2024 having been favored, a direction has been issued to pay him the salary that has accrued due with effect from November 2022, within a period of 4 weeks. First come. A further direction is also given to pay him salary as due and admissible on regular basis. First, next one. Who appears for the OP? As for admission stage.
It's in the orders.
And it is secret. Having heard learned concept, learned AGA appearing for the appellant state and having perused the appeal papers, we decline indulgence in the matter on the following grounds. Number one, learned single judge has structured the impugned order on an inarticulate premise of doctrine against beggar, B-E-G-A-R. You had written in earlier last month, 2 months ago, beggar. This is not beggar, beggar. Enacted in Article 23 of the Constitution of India, as has been broadly construed by the apex court in state of Gujarat versus Hon'Ble High Court of Gujarat, AR 1998, SC, so and so, so and so. First, the Karnataka High Court in the case of has held that even if a prisoner is serving the sentence is made to work within the precincts of the jail, he has to be paid some wages. First one. Next paragraph. It hardly needs to be stated that an employee who has worked for a particular period, even during the pendency of a disciplinary proceeding, cannot be justifiably denied the wages that accrue because of his toiling. First one, that is the underlying philosophy of Article 23 of our Constitution. First, thus the reasoning of the learned single judge, regardless of arguable infirmity, does not warrant interference of this court. First, next one, in the above circumstances, the appeal being devoid of merits is liable to be rejected in limine, and accordingly it is. First one, the order of the learned single judge shall be complied with within an outer limit of 8 weeks. First one, registry to send a copy of this order by speed post to the respondent employee immediately. Okay. Nothing stated herein above shall cast a shadow on the pending case wherein the respondent employee has called in question the disciplinary proceedings. Okay. Then he send a copy of this order to sign. Next.
Senior Lordship, we put up next week. I pray because
next at the request of
obliged Lordship.
Yes, Mr. Brusadov.
My lords, kindly see the impugned orders. My lords, the repetition.
The delay of 231 days, long delay of 231 days in filing the appeal. First of all, we do not find any plausible explanation for the delay proved. First, therefore, the application in IA number 331 of 2025 does not merit favorable consideration. And accordingly, it is serial number 7. Yes.
My lords, kindly see page 31. That is the operative portion of the impugned judgment order. In fact, the writ petition filed by the petitioner was dismissed. But a compensation of 2 lakhs rupees was imposed, my lords. The gradation list was challenged after 30 years, my lords, by the present respondent.
Sure. That's it. Issue. I heard, look at AG, Mr. Behura.
That's there is a delay.
The case is made out for issuance of
Delay of
95 days.
both on merit and on delay application. First one, issue emergent.
When it's appearing for the respondent, when it's appearing through VC, I'm for the respondent.
Going so appears for the respondent employee. How many?
Yes.
One was
Respondent employee. Okay. You file objections to AA if you want. Okay.
Yes.
In fact, my lords, I am not ready in matters.
We'll have it next week.
Yes.
22 manors that is covered by manors, covered by judgment of the Supreme Court manors, that is Sheila dedicated contractual out.
Mr. Behura, just looking. If it is covered, then.
The lordship call next week, I'll go through.
Yes, next week we'll do.
Except manors, 38 manors. Except 38. On one manors on this Thursday manors on 25th
July.
First week of July.
25th manors.
No.
25th of this month. Because he is getting manors, not getting the pension manors.
What will happen within 1 week?
Manors posted to manors.
On first of
Yeah. Like 9 meters. 25, 9 meters.
Yes, you can put on 25th.
Yes.
Mr. Behura, 25th.
My lord.
I have given a copy.
Okay.
See, the copy did.
Previous item 23, 83651 of 39.
Petitioner retired welfare extent.
Put off this point.
Petitioner retired welfare extension officer. Petitioner retired welfare extension officer. He challenged the dean of inquiry before the honorable single bench, but that was dismissed. Allowed for interim order given, they have dismissed. Now, by virtue of time, the departmental already
Proceedings are ended.
Already the inquiry report submitted before the approved authority. It is for dropping the charges, my lord. I am submitting
report. Whether on that report,
it is
competent authority has taken the decision.
Not taken decision.
Yeah, he has to take the decision. He may not agree with the report.
Well, they have not taken decision of submitting. But copy the inquiry report.
No. The report we have understood. The report is supporting.
Well,
it supports your case.
Well,
that's right. But report is not binding on the disciplinary authority.
You are bright man.
They have given a copy to you.
Petitioner has some applicant submitted a copy to me, so and perusal I am submitting one copy.
No, that's all right. We'll assume that there is a report in your favor. Copy is given to you. You have not filed objections to the representation to the report. No question arises because it is in your favor.
That is already that is.
The competent authority has to take a decision on the report.
Well, my lords, the order is that, my lords. My lords, kindly see page 128, the impugned order. Accordingly, this court directs the disciplinary authorities to conclude the de novo inquiry within an unextendable period of 2 months.
conclude the de novo inquiry.
My lord.
But I challenge is the de novo inquiry could not have been initiated at all.
No, in the meantime, already dinner inquiry done.
So it has gone in your favor.
That's why I submitted. It is my humble submission is the
petition appeal has become infected. Itself has become infected. May not. That comes to say that the authority should accept the inquiry report.
That is up to the disciplinary authority.
That's what. Disciplinary authority may agree, may not agree with Anyway, the learned single judge has directed the disciplinary authority to take a decision on the report. Let them take that decision. We'll prescribe particular period. And if they do not take decision, then inquiry is deemed to have been abandoned. Dropped. An employee, a delinquent employee who has been undergoing a disciplinary inquiry for a particular culpable misconduct, he is knocking at the doors of appellate court for laying a challenge to a learned single judge's order dated 31/1/2025, whereby his WPC number 10970 of 2024 has been disposed of with the direction that the disciplinary authority has to take a call on the inquiry report dated. What is the date of the report? Inquiry report is dated.
Dino inquiry. Dino 3/4
report. Now it is given in your favor.
That is communicated by inquiry report, inquiry officer 15/11/2025.
Report communicated to the employee on
15/11/2025.
2025. First off, learned counsel, kindly be seated. Learned counsel appearing for the appellant submits that the impugned order is unsustainable in as much as every employee is entitled to a fair treatment and not to be subjected to repeated disciplinary proceedings. First, Mr. Behera appears for appellant. You appear for the OP. Learned AGA, Mr. Behera, appearing for the OP respondents, resists the appeal, contending that now the inquiry report holding the appellant not guilty having been submitted, this court may not undertake a deeper examination of the matter unnecessarily. First off, next paragraph. Having heard that the counsel for the party and having perused the appeal papers, we broadly agree with the submission of learned AGA that no purpose will be served by undertaking a roving inquiry in the matter at our hand, in as much as the inquiry officer has already submitted the inquiry report holding the appellant not guilty. First of all, what remains to be done now is that the disciplinary authority has to take a call on the said report within a reasonable period. First of all, next one. In the above circumstances, this appeal is disposed of, directing the disciplinary authority to take a call on the inquiry report within a period of 6 weeks, failing which the inquiry shall be
some more time.
8 weeks. Failing which the inquiry shall be deemed to have been dropped for all practical purposes. First. No quorum. Yes. If you do not take a decision, then inquiry closed. Yeah.
Only. Section 24.
24, my lords, this is Hemant Chotra that is
24.
Block grant pension.
17067 of 23.
My lords.
It's covered by that judgment.
No, my lords, that is fixed for hearing.
Hearing 197. On this matter, along with the writ appeal number 197 of 2024. Well, delay how many days?
My lords,
23 days.
124.
124 days.
Then we have to issue notice.
My lord.
Heard the AGA Mr. Behura. First off, he submits that in identical matters already several appeals have been admitted. One of them being writ appeal number 197 of 2024, and therefore matter requires deeper consideration. First, there is a short delay of 124 days in filing the appeal, and application in IA number 1699 of 2025, supported by affidavit accompanying statement. Next one, in the above circumstances, issue emergent notice, both on the main matter and at the delay application. Returnable within 3 weeks. First, applicable within 3 weeks. Yes.
Title 25, date of instant 1 of 1225.
My lords, so this matter may be taken up next week.
The supplementary listing, supplementary listing.
Not this way. Yes. This matter relating to what?
No, it's a case. Yes. It's a matter, my lord. I was appointed as staff nurse in the year 2007.
No, it's the prayer.
Well, it's
the relief granted to you in the
relief granted was I was regularized, and that the regulation order was recalled without any notice. Learned signature says yes, I'm the signature verified that my regular appointment was in consonance with the rules and regulations for me.
There are on this matter the week of the next in the days of
Item 26.
Kindly pass over.
Pass over.
Day after tomorrow.
Yes, Mr. Monkey, what is this matter?
This is a appeal on behalf of the petitioner. Delays.
Can you condone the delay?
138 days there.
138 days. You condone? Appeal is filed after booking a delay of 138 days and an application in line number 1873 of 2025 is filed. An affidavit is also annexed to the application. First time. There is a short delay. It is not a case of long delay, and a plausible explanation is offered for the delay proof. First off, there are some arguable points in the appeal as well. First off, therefore, throwing the appeal without condoning delay would not do justice to any of the parties. First, after all, condonation of delay will not add merits to the appeal to the disadvantage of the other side. First off, next, in the above circumstances, application having been favored, delay is controlled. Above the consent for the appeal. And AG appearing for on request appearing for the response. Okay, then you
this item 27, date of 79 of 2025.
A copy not, sir, my lord. Respondent. We'll solve the copy by tomorrow.
Next week we'll call this.
And next.
call next week. In the meanwhile, copy of the appeal memo along with all the documents be served on the other side. Yes.
Finish item 28. Meet appeal 122 2025.
Three. We don't understand. Without any notice being ordered, how notice the registry will show the name of how they will appear, how they will show, name will be shown. Is there such a rule in your state? That's why. Video it can be filed. How can wakalat be filed even without their notice being issued to others?
He is not a caveator also.
Not a caveat.
Because they might be contested in the lower court below, so challenging the consolidation proceeding. Knowing about the fact, they may appear in advance and file the Bhaklatanama by that, either by way of a caveat or because name is reflecting.
Limitation notice. Limitation notice.
Was issued?
Yes.
It was issued to you.
Yes.
On 8/1.
28 days. It is on 5/2, Milord.
5/2.
It is on 5/2. Can have a glance.
No, even on 8/1, issue notice to respondent by split post.
Yes.
Already notice.
No, therefore you have appealed.
Yes.
You are right. So it condone the delay.
Milord,
28 days.
possibly delay was condoned. Kindly have a glance.
Delay is condoned.
5/2, my lord, order, Milord.
5/2. No. 5/2 is not that. No delay.
No delay. 5/2 is order is there, but not condoning delay. It only says shortage of postal stamp to be made.
28 days is delay.
We condone that delay.
Yes.
The appeal is filed after condoning after broking a short delay of 28 days. First of application in high number, supported by affidavit is filed. 6 condonation. First of delay is short and explanation offered is plus. First of. Therefore, application is allowed, delay is controlled. Okay. Next.
Item 29. Meet appeal 161 of 2025.
Copy दिया ही नहीं.
536 days, Mr. Monty.
Milord, 536 days.
Long delay.
Long
What is the?
They want that copy needs to be served upon them.
Have you received the copy?
No, I have not served. Tomorrow.
Next week.
Next week.
In the meanwhile, copy of the application and the affidavit to be filed.
Copy to
be served.
In both limitation as well as in
yes. Yes.
Title 30. Meet appeal 1706 of 2025.
30 days नहीं. करो. Payment नहीं देना.
414 days. State Mission Director.
Yes, Mission Director.
Your appeal. Mr. Monty.
Yeah, the government is there. Government.
State Mission Director.
Yes.
Now, what is the matter?
Milord, I have not gone through it because I am in
2 weeks at the request of.
Can you take next week or?
Next week.
Next week.
Finish item 31. Meet appeal 1720
This was issued on the last occasion. This was issued on the last occasion.
In February.
Months.
I think accept notice. AGA accept notice. 2 and 3 have been. What is the report?
2 and 3 notice is heard. No, 2 and 3. There are volunteers to also notice for 2 and 3. What about 1? 1 by speed post. Service is done. Service is sufficient. Service and OP number 1 is held sufficient. Response number 1 is sufficient. First, 2 and 3 are represented by learned agencies.
Because there is delay of 3 days in filing.
There is a short delay of 3 days in filing the appeal, and application is also moved seeking its consolidation. First half. Application also delay. Yes.
To finish item 32, delete appeal 1/7/2025.
Same. Only delay is 6 days.
No, 6 days. Okay.
To finish item 33, delete appeal 1/7/2025.
May I please, Your Lordship? Only 36 days delay, Your Lordship. Similar matter, Your Lordship.
Very.
My Lord?
Similar matters admitted.
Yes, Your Lordship.
Issue emergent notice. Learned, who are the OPs?
All the government officials, Your Lordship. All are the government officials.
AG, Madam AG,
In fact, it is allotted to Mr. Panda.
It will say Panda, Mr. AG, Mr. Panda, on request accept this for all respondents. First up. An application in IN number so and so supported by affidavit is moved seeking condonation of delay of 6 days. First up. Delay is too short.
36 days.
36 days.
36.
Delay is too short. And the plausible explanation is offered. Delay condonation. Next.
Obliged.
Delete appeal 1/7/2025.
No one for the petitioner.
Nobody.
Nobody.
Call up to 3 weeks to enable counsel for the appellant to come and argue.
Item 35.
Same Miller, same lawyer, same 35.
2 days delay is that we condone.
2 days delay.
In both cases.
Both cases. Both cases 2 days delay.
Application in IN number 4289 of 2025 supported by affidavit is waived and the short delay of 2 days grouped in filing the appeal is condoned. Next, same order. Again 2 days only.
Only 2 days.
Only 2 days. Same order. 21st, same order. Mr. Mohanty will accept notice in both the matters, na?
Yes, ma'am.
Both the matters, sir. No private parties.
Have also not served copy upon asking her.
182 you can appear.
Yes.
Kalinga Weavers Cooperative Spinning Mills.
No, they have their own panel.
Issue emergent notice 2. 3. Same question.
3, only 3. 1, 2, we can.
182, Mr. Mohanty. 3. Go to the 35.
34 and 35 possibly same matter. Same delay, 2 days of delay, possibly.
Same order. Yes.
Section 36, delete appeal 1890/2025.
Since the lordship, it's a state appeal. It has a delay of 209 days. Should
Mohindra Datta Sharma is followed.
Yes, Your Lordship. For compensation allowance, should we have enumerated the grounds, Your Lordship. Here, Your Lordship, in spite of repeated, has served, Your Lordship, for only rendered only 16 years of service, out of which 12 years and 8 months and 29 days is qualifying service, as opposed to 24 years of pensionable service, Your Lordship, of Mahindra Datta Sharma. He had rendered 24 years of pensionable service, Your Lordship. But the defendant here has only rendered 16 years of service, out of which only 12 years, 8 months, and 29 days is qualifying service, Your Lordship. The second ground is that there has been no family tragedy or This signifies a case of in Mahendra Singh Datta Sharma Yet case, Your Lordship. And the third ground that we've taken is that Rule 33 of the OCS pension rules states that dismissal or removal of a government servant from service leads to forfeiture of his past services, Your Lordship. He was discharged from his services for unauthorized absence.
Dismissal.
Not dismissal. He was discharged from services for unauthorized absence.
That is not applicable.
And Your Lordship, in spite of repeated reminders, paper publications, he did not appear, neither gave his reply to show cause, nor appeared before the medical board, Your Lordship.
Take notice. Issue. Any contempt petition in fact? No.
No.
Issue emergent notice. Returnable within 3 weeks. Yes. Both on merit and in matter and yes.
Lordship, I would seek some time, Your Lordship.
But here have appeared suo motu.
Madam needs.
Yes, my lord. Let my learned senior serve me a copy of the limitation petition.
Yeah, you get copy.
I will.
We'll have it up in 2 weeks. Call up for 2 weeks. The meanwhile, AGM madam should serve a copy of the application and representing the.
My lord, 3 to 4 and 6 to 12.
Yes, my lord. So in 38 serial number, there is a delay of 5 days only. Yes, my lord, there is delay of 5 days in filing the appeal. 5 days.
On merits, say something.
Actually, the appellant was absent during that period. He was to his relatives' house. That's why we could not file in time.
The learned single judge says it is not death come retirement gratuity. It's not DCRG. Para 13.
Sir?
On merit. On merit.
On merit. Merit, sir, actually the appellant was the nominee for the gratuity of his PUC. The PUC submitted all her pension papers during her lifetime. But unfortunately she expired.
What PUC?
PUC.
Yes, sir.
The petitioner is nice. Like, the PUC was unmarried, so she nominated her nice as the nominee for the gratuity only. But unfortunately she expired before disbursement of the gratuity.
So
in the learned single judge held that since the nomination is not filed during his service period, it is not tenable. My lord, Rule 52 says he can file any time after joining a pensioner. Rule 53. A government servant shall at any time after his appointment in a pension will stand make a nomination. So he has made a nomination after retirement before submitting the pension papers. This is the
not because he ceases to be employed.
Yes, that is why.
During employment, 53 similar rules are interpreted by various high courts.
Here, sir, the Orissa pension rule 53 is clear. He can file also.
Read.
At any time means not after retirement, during employment.
During employment, probably the reward is also.
This is one. The government servant shall at any time after his appointment in the pensionable establishment make a nomination. So after any time does not mean after retirement.
There is also cause he could not file because his 7th pay was not fixed.
No, that's
so after his fixation, his last pay was determined, then only he filed his pension papers and along with that is a nomination.
Not like that. That's not the law. They could say it is not nomination under the Insurance Act.
It is on pension of 56. 56 does not end that during his life period. It is not mentioned there. He can file after his joining in a pensionable establishment and any time before submitting the pension papers, my lord.
If not, if very you are manhandling the provision of the rule.
No, this is my submission, Mr. My submission.
Cannot be correct. After any time has to be construed in the text and context of the rule. After any time is not the run of the time of Stephen Hawking.
Then my lord, the pensioner who was unmarried, somebody has to get his discharge in where it will go.
They should go and obtain necessary order or decree at the hands of the civil court. That's the law. Section 11 of CPC. 68 or 69 Supreme Court.
My lord, you can see rule 52 also, along with 52. Gratuity the case of death and retirement in absence of having members.
52.
52. Where a government servant dies in service or after retirement.
Sir, while reading the law, you should not swallow the words. That is first requirement. Every word should be read. You have swallowed that one word while he is swallowed by you. You cannot do that. Where a government servant dies while in service or after retirement without receiving the amount of gratuity and leaves behind him no family, has made no nomination. The nomination made him does not
has to go by succession.
Has to go by succession certificate. You have to obtain the succession certificate under the Indian Succession Act.
Then Indian Succession Act where the nomination is not made, her nomination does not subsist. Can this clause B of the Rule 52?
In the case of not subsist in Rule 53, yes. Where nomination is not made or the one made does not subsist. That is the meaning. So the one made does not subsist. Fits into the parameters of Rule 53. Therefore, you have to go to civil court and obtain the succession certificate.
Had you received pension after retirement?
No pension, because before receiving pension, she died.
Then it is written like that. Yes. You read it again. Without receiving the amount of gratuity or leaves behind him,
then succession
no family, then succession certificate is required. So here is a case where he had not received the pension so he has to go for succession. Had he received, things would have been different.
Let's look into it and come back.
My lord.
Because the employer cannot decide whether the terminal benefits of an employee are given to the right person. How employer will decide? Very difficult. Suppose tomorrow somebody comes and says, no, I am the widow, I am the successor, I am the legal representative of the estate of the deceased. What the government should do? Therefore, in the wisdom of the government, with the accumulated experience, it has enacted, promulgated Rule 52 and 53. 52, 53 are cognate rules. They have to be read together. Your case fits into 52. It does not travel to 53. Because 53 has certain building blocks. At any time after the appointment does not mean after the retirement. Otherwise, the rule would have been structured at any time during his life, at any time during which he lives. That is not the rule. We can interpret the rule. We cannot manhandle the rule. Will you look into any, will you do research and come back, or will you pass the order now? Yes, sir, please tender. Rule 52, read with section 9 of CPC. In the light of Dulabai.
It may not 53 one double I also provides a 53 one double I.
No family. The nomination made in favor of a person, persons, or a body of individuals, whether incorporated or not, applicable to you.
Double I, the government servant has no family.
And no family.
This case he has no family.
No, it will not go to that level at all.
In any case, yes, to go for it.
Even two
Yes, also,
has to satisfy one.
yes.
Sub rule 1 to be satisfied, then you will travel to 2. Not otherwise. It is not 2, it is Roman 2. It is a subclass.
Roman 2.
Therefore, sub rule 1 has to be satisfied. Then you can travel further. Regardless of what the learned single judge has said, the end product of the judgment is sustainable. Reasoning, yes, there may be arguable case for you. But if it has brought about a right result, no case for appeal. Because you have to show not only impugned order is wrong, it is unsustainable. You may succeed in showing that it is wrong order. That per se is not sufficient. You have to show it is wrong and unsustainable. That unsustainability is not there in your argument. Because the end product of the order is sustainable. Operative portion of the order is sustainable. If you permit, we will give dictation now. We are waiting for your permission.
May as your lordship decide.
Or you want to do some research and come back?
Yes, ma'am.
It's appears to be the broad view of various high courts. No.
Is that therefore the province of rule
will not be applicable to
will decide and determine the permanent gratuity of the person on such person as the successor of the government servant in terms of substance and humanity.
This intra-court appeal is directed against a learned single judge's order dated 15 October 2025, whereby appellant's WPC number 2439 of 2022 has been negative. First, essentially, in the said writ petition, the appellant had claimed, had structured the claim for death cum retirement gratuity, gratuity and tangible benefits of the deceased employee on the premise that the employee had nominated her or him, nominated her in the service records. First, do you want to say anything, madam? Can you be seated? Learned AGA appearing for the state and its officials resists the appeal making submission in justification of the impugned order. Next one, having heard learned counsel for the parties and having perused the appeal paper, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge that nomination contemplated under the Orissa Pension Rules 1992 is the one made by the employee after the employment and not before the retirement. Although Rule 53 in so many words does not say that. First, it hardly needs to be stated that in service jurisprudence, the employee makes the nomination soon after his retirement, soon after his employment, and before emitting office on retirement. First, the contention of learned counsel for the appellant that the provisions of Rule 53 employ the expression after appointment, inwards. And therefore, even after retirement, such a nomination can be made if accepted, will fall foul of the intent and policy content of the person. We repeat that after the appointment means before the retirement, there being nothing contraindication. First, next paragraph. The learned counsel appearing for the appellant is not justified in banking upon the text of Rule 52, which contemplates obtainment of succession certificate under the provisions of the Indian Succession Act 1925 in circumstances of the kind, inasmuch as there is no valid nomination, and that would fall within the parameters of this rule. First, it hardly needs to be stated that the state government, being the rule-making authority, has promulgated inter alia Rules 52 and 53 of 1992 rules, working with the enormous experience gained over the years. First, in the above circumstances, the appeal being unworthy of merits is liable to be rejected, and accordingly it is. First, liberty reserved to the appellant to work out her remedy elsewhere in accordance with law. And in that connection, all contentions are kept off. Yes.
So this item 39 is appeal to 2011 of 2025.
Madam, Your Lordship, maybe kept to next week. The file has not been.
Next week.
Obliged.
On the question.
Item 14, we complete 8/3/2024.
Managing the order passed by the London single judge on Register 4, page 130. Page 130, kindly see page 130.
130.
130. Paragraph 5 plus. I'm placing paragraph 5.
Now this is state appeal.
State appeal. No, this is the paragraph 5 of the order, rate order.
Accident.
Impugned order.
All right. Accident occurred on 12/2/2020. At what time?
2020 accident occurred. Like police license validity 16/9/2020. Policy is valid. My police note is valid. 16/9/2020. That's the order.
To midnight of 16/9/90, 2020.
The Lord Single Judge holding that on 3/8/2020, the litigant is claiming insurance.
When you bought
That is the wrong. That is the
when you bought the policy.
Policy lordship annexure of 1, that is 27 page.
No, you're asking the date, not page.
When did you purchase that?
When did you buy the policy?
Policy lordship, that is the police annexure 74. Page 74. Page.
Why can't you tell the date?
Lordship. That is policy 74. Page 74.
We're asking the date, not page number. Give the date on which you bought the policy.
Police. The annexure.
We are not asking for annexure. We are again asking for date of the policy and
Date of the policy lordship to the crime to the date policy and title code.
From 17/9/2019 it is. One second.
19, it is a cover.
One second.
Extra
17/9/2019 to it starts operating up to midnight of 16/9/2020.
Lordship. That is the lordship.
So you say Lord Single Judge is not right in holding it as 2019.
No. Lord Single Judge is saying the claiming is made. The insurance claim the insurance on dated 3/8/21. That is the delay.
3/8/21 you claim.
No, I am not claiming is irrelevant. When the accident took place, that's the cause of action.
12/2/20. 12/2/20.
Oh, well within the time. 12/2/20.
12/2/20.
Who appears for the other side?
Other side is one.
I'm appearing for respondent number 1 and 2 in favor of Adam Malik House.
Insurance.
Yes.
Tata AIG 1 and 2.
Yes.
Yes, what do you say? Lord Single Judge is not right.
I'm
The
praying
policy is valid till midnight.
I'm praying for 2 weeks time.
No, Lordship, that is what is the predicate government. It is the litigant. Litigant. No, Lordship, I'm.
Will you not give 1 week to your system?
No, Lordship.
Your lordship.
No, 1 minute to visualize my predicament. What to visualize my predicament? The litigant is poor man.
Correct.
Now vehicle is prepared 2021. Now the vehicle.
What happens will fall down within 1 week.
Lordship, the vehicle is not running to the.
Not up to 2.
No, Lordship, 25. No, Lordship, 25.
You are unkind to your system.
No,
therefore, we want to be unkind to you.
I'm Lordship to go down.
Don't go down.
25 Lordship to that.
Hold your head high. That's what Tagore said.
No, Lordship.
Where the head is held high.
I go down. No, Lordship,
you hold high.
25 Lordship.
2 weeks. Next.
Lordship, I will approach 25.
2 weeks. Next. On unreasonable stuff. Yes.
No, Lordship gave a date.
Give something.
List is supplemental. Lordship.
Yes.
Let it be supplemental list. So that
Let him come back. You get unkind to your system. You can't have what's there. Yes. Yes, Mr. Mukherjee.
Yes.
Very small things are also doing like this. See, madam, sister wants 1 week time. He says no, as if heavens are falling down. Well, really, we do not understand. Anyway, yes. Yes, Mr.
Well, it's Orissa school.
He did not respect the senior advocate also. He's already on his feet. Yes.
Well, it's Orissa School Education Program Authority is a OSEPA, is an autonomous authority regulating school education in the state of Orissa. Now, the petitioner before the appellant before your lordship was working as an assistant director in this said organization. When, my lords, it was discovered that one of his certificates of MCA, that's Master of Computer Application, has been obtained from a university in 2006, which, my lords, in 2016 has been declared to be a fake university. So on this information being revealed to the authority, that one of my certificates was from a fake university.
Fake, not fake certificate.
Not fake certificate.
It should be fake university.
Fake university. And that too in 2006, which was declared to be a fake in 2016.
Who declared it a fake?
The UGC, madam.
UGC.
The UGC.
Whether that word fake is there in UGC Act?
Yes, madam. I'm not sure. I'm not sure. I have to check that. Because there were certain universities, they
enlisted.
Yes, madam.
Being ineligible universities, non-functional universities, like this, there is a provision.
No, here I think they have used the word fake. I think I've seen it. They have used the word fake. Whether it is they are competent to do that or not, I have not looked into that part. But I accept that, in fact, at page 34, it's indicated in the order itself. It's indicated that
it's a fake university.
That is a fake university.
Page number?
That's 34. That's the impugned order, madams, before the learned single judge. Page 34, second paragraph, if your lordship sees. Annexure 8 begins at page 33. At page 34, your lordships will find the second paragraph in that page, third line.
Fake university at page number 22.
Yes, madam.
And as per recent data available in the website, in this context, the show cause note, imply submission equals and proceeding on the challenge is authentic.
So, madam, may I just submit the facts thereafter, madam? So when this was discovered, a show cause notice was issued to me. In the show cause notice, I indicated that, be that as it may, I accept that it's a fake university. Maybe it's a fake, it has been declared to be a fake university. But I still have the requisite qualification for the post that I'm holding.
Without that also?
Without that also, irrespective of that.
How?
Because subsequently I have also done my MBA. I have also passed MBA. That is not the requirement. I will take your lordships to the requirement of for the post that I was holding. Bachelor of Engineering was there with me.
That is the prescribed.
That is the prescribed. That was the prescribed at that point of time, which has later on been changed to Bachelor of Computer Application. Bachelor of Computer Application was not in prevalence at the time I passed out. It was electrical engineering broadly. And
that satisfies the requirement.
That satisfies the requirement. Subsequently, in 2014, they said that for this post, what is required is Bachelor of Computer Application from 2014 onwards. But I was recruited much before that. So,
when you were recruited, what was the prescription?
Well, it's, at that point of time, it was just a graduation was the requirement. Not even a engineering degree.
So what you say is regardless of fake or not, you are also qualified.
I am qualified to hold that post because I was promoted after I joined my service. I joined my service in 1998.
1998?
98.
This certificate was necessary for what purpose? MCA certificate?
Not necessary. I had whatever qualification I had submitted.
Did you say that in your show cause notice?
Yes, I have said.
So show that. You appear for the OP?
Well, in fact, if your lordship sees, I don't find them anybody representing them. Your lordship will kindly see order dated 9/9/25. The court, yes, madam, this coordinate benches order 9/9/25, where the entire case has been encapsulated, and the court felt that a separate notice was required to be issued, and notices were issued. They have appeared, but today I don't find any representation from the office. Should I read out this order?
No. What was the prescribed qualification for assistant director, MIS?
It was Bachelor of Engineering. At that point of time, it was in fact, OSEPA does not have a prescribed guideline. In the absence of prescribed guidelines, it is the central rules which will prevail. For the central government provides that bachelor, there are notifications to that effect. That where there are no guidelines prevalent,
then the central rules will
prevail. And the central rule provides that Bachelor of Engineering for the post of Assistant Director is the prerequisite, which I had.
And it is not that he procured this certificate at the time of promotion. No. It is not that.
It is not at all.
University, the next paragraph which you did not read, which I noticed, in the next paragraph they say university was not competent to confer the therefore, we can't say that candidate is at fault.
No, the candidate was not at fault. It was just my misfortune that the university took me for a ride.
No, we should answer you okay. What is what Mr. Mukherjee says? Assuming that it is fake, it is not that I have complicity in that. Number one. Number two, even if you ignore that certificate, still I am qualified. That aspect has not been considered by the authority, though he took up that contention in reply to the show cause notice.
But that has already been taken by the Honorable Single Judge.
No, he has also not considered that aspect.
Single Judge's discussion is frugal. 2-3 aspects have been lost sight of. Number one, where is the complicity of the candidate? It may be a fake certificate, but where is his complicity in fabricating fake certificate? It is not a case that he has fabricated some document. He is bona fide, I believe, went to the campus, studied there and secured a certificate. But the campus had no recognition.
That's right.
Therefore, no guilt, moral turpitude can be attributed to his act. He bona fide, who will go and ask, show us how your university is established, which are the gadget notification, whether recognition has been got to you. You will not get the admission at all.
No, they must have also mentioned it, related to such and such. Without that, the certificate would not be.
Number one, assuming everything is fake, because it is like a fruit of a poisonous tree. Fruit of a poisonous tree is also poisonous. Assuming that argument, the requirement is complied with even otherwise. Except that you changed its nomenclature in 2012. Nomenclature may be changed, but if the content remains the same, even that aspect has not been examined. You appear for the OPs.
OSEPA is a separate ballot.
In fact, notices were issued. The order which I pointed out, your lordship will notice in paragraph 3.
Is to 3 and 4.
3 and 4. Notices were issued. They have appeared. They have appeared. Mr. P. K. Mahanti and his office associates have appeared, but
their names are not printed.
Their names are also printed in the
cause list. Their names are printed, man.
Well, they are not coming here. They are afraid of Mr. Mukherjee's merits.
Definitely, your lordship.
We'll call it day after tomorrow. Inform them.
As well.
Yes. There are some judgments in Law of Education by Arul Selvam, he has quoted 2-3 judgments of the apex court on the same line, where in what was granted by the university is incompetent, but there was no complicity of the candidate as such. Number one. Number two, you were otherwise also satisfying
with the qualifications. Bereft of that certificate, I am still
will be inside. Day after? Or next week will call us.
As you know, Chairman, and earlier was better for me and my client.
On Friday we shall.
Friday is a holiday, madam.
Friday is holiday. So Monday we will call this.
Monday, my lords, may I only pray in the first list now?
Because shift it to very short point. Yes.
Oblige.
In the meanwhile, Mr. Mukherjee, tell your friends to.
I have already taken note of that author.
Call this matter on Monday to enable the counsel appearing for the answering respondents to come and argue.
Oblige.
Yes.
Is 42, date of it to sign 8 for 2024.
22 I pray next week.
Next week, if the question.
Item 14, date of it 3017 of 2024.
Yeah. None appears. Well, up to 3 weeks.
44. Is Hajra 44, date of it 2024.
44 also means Ranasini has mentioned that initial time. And also mentioned that's a regularization matter. This petitioner is item 44 Lordship. Is seeking for time. Just may inform that Lordship has already adjourned the matter.
We have adjourned the matter. Not adjourned. You want time?
No, I don't want time. Well, understand, I already intimated that counsel for the respondent, but it adjourned the matter. If it is not adjourned, also I pray for this one passover. It's a regularization matter. Notices have already been issued.
Notice already issued.
Well, 25/6/2025, this appeal been admitted and notices were issued, Lordship.
All right, next week we'll have that.
Fine.
Next.
46, date of is 8/1 of 2024.
Because I could not drop the file.
Next week we'll have it.
Yes.
Next week. Just see the date. Should not be big rush of the matter of that day. So just put that matter on particular day. Yes.
Next week,
Item 47. Date of is 3/2 of 2024.
Is it Lordship? Lordship, we pray for 1 week time, your Lordship.
1 week?
Yes, sir.
So you want to do some gym and exercise and come back stronger?
Your Lordship, I have not prepared, your Lordship.
Someday, next week, any day of the week when it is, the calendar is free, not put that.
Oblige, your Lordship.
Yes.
Number 58, date of is 3/4/2024.
I'm to the respond number 1.
My lords, I appear for the appeal, my learned senior Mr. Tarun Patnaik. My lords, due to some exigency, he is not available today. My lords, I humbly pray for a week's time.
2 weeks at the request.
Next week, my lord, because
Next week we have already posted many matters, not?
the case is that
Let us. Yes.
Item 49, date of is 5/00 of 2025.
Yes, sir.
49, your lordship, may I pray for 2 weeks' time, your lordship?
2 weeks time you want?
And for the appellants.
That's it. Kindly grant 1 week time because it's not, I'm not opening the.
Okay. 1 week, just see which date. Okay.
One short date because revision case is pending due to.
Yes, because of pendency of this matter.
Lordship. Just Because revision is pending, petition it was dismissed. Since revision is pending in the before the collector, now read that's why precisely there is absolutely no point 1 minute.
Now we'll say that revision be decided independent of this. Will
There is a legal point.
Why revision should be halted? Is there stay order here?
Yes, because but
Yes, got a stay order.
Against disposal of the revision?
I have questioned the maintainability of the revision by a third party, Your Lordships, who was not a party to the appeal.
Whether section says party aggrieved by the order or person aggrieved by the order. That provision which other day somebody showed to me.
Yes.
It is person, any person aggrieved by the order.
Yes, Your Lordship. That is the point.
Any person means other can be other than party also.
Aggrieved party, but the question of limitation, on the ground of limitation, the appeal was dismissed. And now if the present opposite party, respondent number 4, who has filed the revision, if she files the revision, the question of limitation will not be taken into consideration because the appeal was dismissed on the ground of limitation only. So to skip the question of limitation, Your Lordships, they have tactfully filed through a third party, Your Lordships.
Encroachment land. Lordship, kindly come to page 15.
Why we are not taking them back now? All right, put someday when it is free, calendar is free. So what you say is that limitation could not have been the point at all.
Exactly.
Because third party.
Third party, Your Lordships.
That's it. I'll show within 5 minutes because I'll show in 5 minutes. Because thing is, in a OPLA Act.
You're ready now?
I'm ready. I am ready.
I need some.
I am ready because it's a village.
Next.
1 week after, he wants 1 week, Lordship.
No, will come. Some free day he will put it.
That's it.
Interim order to continue.
That's
interim order to continue till next date of hearing only. Okay. Call on. Sorry.
Six. Item 15. Today I am entering my appearance. Where means not inconvenient or something for July.
First week of July. All right. In first week of
Any day also not.
no problem. Whichever day you want. Which day will be convenient to you?
Including Thursday, any day also. 7 or 8. 8.
Yes.
Yes, I think this item 50 was page Robert Service Area 2025.
It is a Lordship. I'm to the respondent, Sir Lordship.
Your respondent.
I'm to the respondent.
Where is your friend?
For sure, I'm being affected by it, but I'm not so sure. They are enjoying a stay order.
They have interim order.
They have an interim order. But if your Lordship allows, I'll just take 1 minute of your Lordship.
But in his absence.
No, not in your absence. I just wanted to tell you what is this case about. No, as your Lordship.
Put it, which did you put for this matter? Same day you put this.
I think this is
It's interim order to continue. Only till 29. All right.
29 minutes. Grateful.
To tell your friend also that court was not happy of the absence of the consent.
I'll just inform them.
Yeah.
Grateful.
Yes.
Yes, item 52. Meter page 1, Route has 7/2025.
Request time for preparation.
You want to prepare this?
Lord, here
2 weeks.
he wants to take time. I'm not objecting his application for adjournment. Here there's an interim order which is affecting the entire public as a whole. The demolition order was passed to remove the house over a public land which is used as a road. That order has been stayed by the Honorable Division Bench. The order of demolition was passed by the Honorable Single Judge. If he wants time, I am not on objecting that, but I want, if your lordship may consider my grievance in that.
Put it on 8. 8. Interim order request now. Interim order to continue only till then. Yeah.
Grateful.
This is item 53, April 1592 of 2025.
That's what they put some notices. They are the impression will not just firstly states. So, problem. Yes, we work that. We work. For the extension. 29th appointment. The 19th appointment.
Yes, I'm very much
Who is in appeal? You are in appeal.
No, my lord.
Who is in appeal?
Petitioner, no, 53. Mr. Panda is there.
Mohanty.
No, NK Panda. I am for the state, my lord.
No, this requires admission. 1999 appointment.
Yes.
And learned single judges make representation for regularization. Petition itself is a representation. 99 appointment. Why he should be made to go one more representation, reject that representation, again come to the court so that he will spend whole of his life in the court.
Last occasion, my lord has also directed to call along with the writ petition.
This one. Not this.
1592.
I'm not sure. We are not sure in there.
29/1/2026 one order was passed. 13835.
99 must be having given benefit of regularization.
Move to the opposite party number 2, afresh.
Our
No, my lords. Learned single bench order.
no, point is, learned single judge is saying, see, this person gained entry to the service in 1999.
21/4/1999.
Correct.
Yes.
21/4/1999. 1999, 2009, 2019. We are 2026 now. Therefore, how can he say that you give one more representation, etc.? That will not do any justice. Where have you considered any representation favorably? Every case is landing in the writ court. He is not here. In fact, we wanted to follow this appeal. One call of 2 weeks to enable counsel for the appellant to come and argue. Yes.
I prefer the password for the day, my lord. This is a matter of regulation. I prefer password for the day, my lord.
Password not possible. It's 3:30.
For the day, my lord. Today, for today. Only for today, my lord. Tomorrow. Let it lie over in the list.
Next week.
Hon'Ble.
Also fix and make it. Just see the calendar and put the not.
Hon'Ble.
Please, item 55. Read the 36 for Occidental 24.
Today also Mr. Swai, private party.
No notice for the issue. What is wrong with this order? How can the court director give appointment to a particular person? Court said we will not. Who appears for the appellant?
The appellant, Mr. Swain is there, K.K. Swain, not present.
2 weeks to enable counsel for the appellant to come and argue.
All the connected matters are there.
Connected matters are also there. Totally 3 matters, no? You some date. Yes.
To that one.
Lordship, I'm appearing on behalf of Mr. Hemant Kumar Mun. He's unwell today. I pray for and pass
Is
over.
not well.
Yes, Your Lordship.
3 weeks.
Lordship, a short date. Tomorrow if possible.
Once when matter is called, if you are ready, we'll hear. Otherwise, no short date. We'll put it because there are many other matters. Yes. Next. 57. None appears for the 57 is state.
57 Malad is State Bank of India in the other side.
To enable counsel for the appellant to come and argue. Yeah, 58. That's fine. Same order. Next. 59. Same order.
May I please, Your Lordships?
Yes.
I would have challenged the order passed by the learned single judge in not granting interest on the gratuity which was released after 17, my lord. Only in the interest part, my lord. During the pendency of this case, my lord, the opposite party have so much to release the gratuity amount, and so far as
the period interest has to be.
My lord.
What the learned single judge said?
Learned single judge has told that, my lord, your lordships kindly have a glance to page. Page 66, it starts from.
Come to page para 5.
My lord. My lord, be that as it may, since the payment of gratuity was admittedly held up due to audit objection.
59.
Para 5 of the impugned order, my lord, page 69.
No, he's 60. You are in 60.
Item 60, 60.
60?
My lord.
Go to 60.
59 would that be?
No, 60. Page 60, my lord.
No, para 5. Who is the OP? Respondent.
This is Forest Development Corporation.
Mr. N.K. Mahanti is appearing normally. May I have your permission to serve a copy, my lord? Let the matter be taken up day after tomorrow, pass out for.
Day after tomorrow, we will push it. He matters.
So in the meantime, person has already been died, and the old lady is only suffering. Only for the part of interest. I am not known.
No, audit objection cannot be a ground for denying delaying payment of gratuity. Wherever gratuity payment is delayed, then the interest has to be paid is the Supreme Court issue. Notice is not yet ordered.
Not at all. The first
issue.
I am permitted serving copy.
Emergent Mr. So
N.K. Mahanti.
N.K. Mahanti.
Yes. Engineer.
For please, respondent. the petitioner to serve copies of the appeal papers along with all the documents. Immediately. First, if that is done, post this matter after 2 weeks. Bring that judgment of perfect.
Yes, I have already there.
If you already there,
Yes, my lord. That is already there in the Supreme Court judgment. I have reported to my lord. But in the order sheet there is no mention about this. But in the file that is there, sensing in this one. May prefer
judgment just take down. I don't have the citation. V.T. Tippeswamy with the state of Karnataka.
V.K. Tippeswamy.
V.T. P for ball. T for training. Tippeswamy versus state of Karnataka. Where Karnataka High Court says, on the ground of audit objections, the payment of gratuity cannot be delayed. And if delayed, interest has to be paid. Bring that judgment.
More. The date may kind of please more.
We have said that they have to serve copy and then it will come.
Yes, more. Obliged.
भारत गोल्ड माइन्स भी अच्छे भारत गोल्ड माइन्स
Let me state that. Oh, why it's an indoor